Boom. Hey, folks. Hopefully people can hear me. I hope people are having a great day. Um, Today was, I think, a good day. Today, we got a verdict, and it was the verdict I thought was the correct verdict, which is always a good day. I have also set a goal, and the goal is for me to drink a. I'm experimenting with a Runkle, and that is a cocktail. I'm not sure naming a cocktail after myself is a good idea, but it is sort of for the cookbook that I'm working on doing. I'm trying to what is it? I'm trying to get this you know get some drinks in there as well. And so somebody was like, "You need to make a drink named after you." I was like, "All right, cool." So that is one of the things I'm working on, I'm tinkering with, and I think I've got something pretty good. I may tinker it a little further. I may do a little bit of adjusting to make it better. But yeah, it looks like this. So yeah, I'll tell you what's in this model, this version, if we hit the goal and when we drink it and so forth. So yeah. All right. Now, one of the things I just want you to notice right at the outset as we go into this particular hearing today, we're going to start by watching the closing arguments, but I just want to show you something here. And I got to actually add it to the stage for you to see it. So,
Lawrence.
What is it? Just notice the front row.
Good morning, Mark.
So the front row has all the police officers right here behind Kelsey for some reason. And what was reported by Turtle Boy reported that apparently the police were given a front of the line access, front of the line privileges in order to sit in the front row today. And I don't like that, because the police are here as citizens, right? The police are just citizens. So they should not be getting front row seats because they're just, they're citizens. They're not citizen plus. And that is not something I really am thrilled by. But let's have a look here at we're going to watch the closing arguments first. The closings are pretty short. And the other thing I'm going to tell you before we watch the closing arguments is a little something about bench trials, because I'm Canadian. We run bench trials here way more often than we run jury trials. So, as you know, I will tell you that by the time the trial is done, the judge, about 90% of the time at a bench trial, already has their verdict. 90%. About 1% of the time, you'll be able to convince the judge that you should win. Now, you might be saying, wait a minute, where's the other 9%? The other 9% is somebody convinces the judge that they should lose. And so more often, when anybody moves the needle in closing arguments in a bench trial, it's by fucking up. That's the most common thing. Rarely do you actually win a case in your closing arguments in a bench trial. Now, I will say they are way, way, way more important in a jury trial. In a jury trial, the jury is going to put a lot of thinking on that. They're not as used to court processes. And so the jury trial, it is way more important to have a good close. But yeah, it's something to consider, right? Okay. How bad would you have to fuck up to affect the verdict, which would be of no fault of the client? I have had a so a case I had, and without giving too much without giving too much detail about it, but the prosecutor in close got pressed by the judge for an answer to a question. And then the prosecutor basically gave a dumb answer, like a really dumb answer. And I watched the judge go, and I saw the prosecutor move their paper over and then start writing, or the judge move their paper over and then start writing again. And it was like, all right, they had a they had a big moment there. You may have touched base on this before, but what would make you pick a bench trial versus a jury trial? So sometimes it's the charges. Sometimes you want a bench trial because the charges are real bad. So, for example, if your client is charged with, your client's charged with possession of bad pictures or some sort of, something where they harmed a child or something like that, you probably don't want a jury because the jury is going to hate the client just because they're charged with it, right? They're more likely to convict just because it's such a horrible thing. There's some trials where it doesn't really make sense to bother with a jury. And what I mean by that is, like, I went to trial on a case, and, there's dozens of cases just like this. But the case involved a whole bunch of drugs. And then the issue was, are the drugs going to be admitted or are they going to be excluded because there were rights violations? And so if you have those rights violations, well, there's no point having a jury, because if the judge agrees that the drugs get excluded, then the case is done. The prosecutor, after the end of that, if the judge says, I'm excluding the drugs, the prosecutor will stand up and say, based on the court's ruling on the admissibility of the prior evidence, the court calls no or the Crown calls no further evidence and invites dismissal, right? Because you can't prove possession of drugs without the drugs. It just, that kind of follows, right? So there's no point in paneling a jury for that, because what you'd have is the jury gets seated. The case begins in a voir dire that the jury doesn't get to see, so the jury leaves. You argue the voir dire, and then you bring the jury back just to say, bye, we're sending you home. No defense lawyer really wants to dick around a jury just for no reason like that. So you just go with a bench trial. But some things, there's some that I always, if it's available, want a jury trial. Self-defense cases, I often want a jury trial because I think that juries are better at assessing self-defense than judges are. Juries have been in a fight. Juries have had to walk home late at night in a bad neighborhood, right? Whereas the judge has not in decades. The last time the judge had to go and feel unsafe anywhere was, 30 years ago. So judges are, by nature of the profession, they're a little more insulated. They're a little more privileged, right? So I would much rather have a jury for that. So those are kinds of considerations, right? Now, one of the considerations, and I don't know, Bradel, we will probably never hear about this from Bradel, right? But one of the considerations on this is there's a particular kind of reasoning error that juries might make and judges are not supposed to make. And the reasoning error is this. You look at Noonan's testimony and you look at, Kelsey's testimony and you say, which one do I believe more? And so if you believe Noonan more, you convict. And if you believe Kelsey more, you acquit. And the problem is that has just involved a little bit of burden changing, because the prosecution bears the burden of proof beyond a reasonable doubt. And the jury, if they do that kind of thinking, has just quietly in their head switched your client over to a balance of probabilities. And so here we've got a judge, and you can see the judge's reasoning is very much reasonable doubt reasoning. Spoiler alert. If you watched my stream last night, I actually called it about how the judge was likely to rule. Spoilers. So the spoilers is I said it yesterday. So yeah. Okay, let's watch here.
26, 2026, Courtroom 2, Lawrence, Superior.
Oh, I mean, she's just ridiculous. She's just a little, yeah.
Superior Court. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311. Scheduled today for continued jury waive trial. Could counsel please identify themselves?
She doesn't want them unsealed. They're going to be sealed.
Good morning.
Good morning,
Good morning.
Good morning, Your Honor. Martha Cooley for the defendant, Kelsey Fitzsimmons.
Good morning. Good morning, Ms. Fitzsimmons.
Good morning, Your Honor.
Good morning, Your Honor. Timothy Gradle. With me is Ms. Healy. Ms. Hassan, Mr. Leonard.
Good morning, everyone. Thanks. You can have a seat. All right, so you folks ready to proceed?
Yes.
All right. I don't say this for the attorneys who know this, but because the government, the prosecution has the burden, they go last. The defense goes first in their closing. And Mr. Bradle, you may proceed.
Thank you very much, Your Honor.
All right, let's jump to here. Now, one thing I immediately went, what? He actually has the, he's got his closing notes apparently handwritten in a little notebook. And I'm like, that is some old school shit. I haven't handwritten closing notes in ever. I do that this way. Is Rob doing all right these days? Yes, but Rob is dealing with some family stuff. I saw somebody who was asking, is it anything to do with his, marriage? No, or his relationship. His relationship seems to be going great. No concerns there. It's just other family stuff, right? So he's been dealing with that, and because he's dealing with that, he has not been able to stream. So it is what it is. But
May it
yeah,
please
Rob's
the court.
not dead. Rob's
Counsel.
He'll be back.
Ladies and gentlemen, Your Honor, June 30th, 2025 was the worst day in Kelsey Fitzsimmons' life. Her whole world imploded. Her fiance betrayed her. Her baby was being taken away. She was going to lose her house, her job. It was an incredible confluence of tragedy that was visited upon her that day.
Now, he doesn't have to be flashy on this one because it's a bench trial, but it's still a great, it still must be a great, it's still a great beginning here. I like this.
That day was about her, and she decided in the midst of
that's awesome.
what you saw testified to here, she decided to end her life.
Oh, I got to check
Patrick
that out.
Noonan, when he came back up those stairs, Your Honor, walked into a suicide in progress. That gun was nowhere near him. That gun was already pointed at Miss Fitzsimmons' temple by Miss Fitzsimmons. She was a couple steps into the room. Officer Noonan, a gung-ho cop, highly trained, a SWAT guy. He'd already been ginned up all afternoon by the insane, ludicrous statements of Justin Elaine. He had that in his head. He walked in, and like all of us are susceptible to, he made a mistake. He shot too quick. He reacted too quickly. And instantly, he realized that he had to adjust the narrative. And that was easy, to just add 6 words to the equation, Your Honor. He said, words to the effect, "She pointed the gun at me." 6 words. What did those words do at that time period? Those words made him the victim. Those words made him the hero. And those words, most important, made him untouchable.
Now, you notice that his wife was reacting very strongly to that, and he wasn't. So, I actually thought that was kind of interesting, just overall, right?
Those words were a defense for his future, his life, his reputation, and they were conveyed to a very willing audience. His colleagues, his brothers, his family, the investigators on the case. So that's really what happened here, Your Honor, and it is a tragedy, and it is something that should not result in any further harm to Ms. Fitzsimmons. This should be over. This should be an acquittal, Your Honor. I want to talk to you about a few of the elements that I know you're going to be concerned about. So first thing I want to talk about, Judge, is the lack of motive and the lack of intent. Because when it gets down to brass tacks, I know that you're going to look at the law, you're going to look at the credibility determinations, and you're going to make your judgment. And here, this case fails the Commonwealth ship founders on the rocks of lack of motive and lack of intent. Let's talk about motive. Everything in life is motive. And it's ironic that, us lawyers always say, oh, well, you don't need to prove motive. But you really kind of do. It's might not be an element of the crime, but motive is everything in this business, Your Honor. Let's look at the motive or lack of motive.
I thought that was really interesting. He's like, you don't have to prove motive, but you do kind of have to prove motive. And the thing is he's sort of right in the sense that we're dealing with a case of intention, right? The fundamental things are going to be, oh, you can't hear me. Okay, 1 second. 1 second. Can you hear me now? Are you able to hear me now? Yes, no. All right, better. All right. So, to start over, if you couldn't hear me, he says you don't have to prove motive, but you do kind of have to prove motive. Like, motive does kind of matter here. And the reason why is because ultimately this is a case of intention. And so the intention issues is, is directly connected to the motive, right? Because if we're going to ask, did she intend to point the gun, at him, or did she point the gun at him? The question is, why would she have done that, right? So I did like this line. I thought it was kind of, interesting. I also like his style here. It's not bombastic. This is a very, it's very much like relating to the judge. Now, we have hit the goal. So this is my current iteration of the Runkle. And so what this is, 1.5 ounces of Bailey's. Because somebody said that the Runkle has to have Bailey's in it. And all right, fair enough. So 1 ounce, I think, I got to check the exact measurement, of creme de cacao. So a little bit of chocolate flavor to it as well. So it's a little chocolatey. And then 1 ounce of a chili pepper liqueur. And so it's creamy, it's chocolatey, and it has some spice to it. So now I'm going to experiment a little more. I'm going to try making it with a little bit of something else. I got to figure that out. But somebody's saying, what is the it's Ancho Reyes chili liqueur is the stuff I used. So that gets me a kind of creamy, chocolatey, spicy thing. It's actually quite tasty. And it's not super it's not too hot, but it's actually quite pleasant. So I will experiment with adding some other stuff. I'll experiment with a little bit of tweaking it in various ways. But yeah. Will I do a live tomorrow? I'm not sure. I've got a bunch of stuff I want to talk about, but yeah. So yeah, not too sweet. It's a little sweet. It's kind of a sugary drink, but it's quite pleasant. I like it. And I've got no issue with that. I might try to add a little bit of a cinnamon liqueur to it and just see about adding that sort of element, like maybe some Fireball. Yeah, I think it's an interesting sort of cocktail. So that's the current iteration of the Runkle. Didn't get the chance to send last night. I might have a cocktail that tastes like the spicy tamarind candies from Mexico. Your drink should be bitter and sour. Make a sweet drink recipe for the missus. I like that idea. But yeah, the adding the making it out of the Baileys was kind of a thing there. So because now it's a Runkle, which includes Baileys. So try a cinnamon stick. Fireball is too much. If I was going to put Fireball in there, it would be just a little touch. Yeah. Halsey says, I'm a bartender. I'd love to help you make your signature drink, but I'm in New York. We can talk. We can try to figure all that out. But all right, let's roll.
Fitzsimmons and Noonan are colleagues. They have already bonded over shared tragedies, shared experiences. They were okay with each other. They were friends. Kelsey thought well of him, and she thought he thought well of her. She knows he has a family. She knows who his family is. She's not going to harm this guy. She knows, Your Honor, that he didn't do this to her. She knows that Justin Elaine did this to her. And she's probably most important, she's been in those shoes before, serving restraining orders. She knows she's just a messenger. She knows he's just a messenger. This was the worst moment of her life, and she wanted to end her life. And how did she want to do it? She wanted to do it alone. She didn't want to involve these officers because she knew this was a selfish act. She came in here, and ironically, the most credible evidence that came into this case, Your Honor, was from the one person that didn't have to testify. And she came in here and she chose to testify. And she waived her rights and she testified. And she showed, Your Honor, that she's a moral person. She's a caring person. You will sit down and you'll deliberate, and you'll be drawing the inevitable conclusion that Kelsey Fitzsimmons is a moral person. You have to contrast that with the callous treatment of this case from the other side. Hey, we're going to go serve an order on Kelsey Fitzsimmons. Her ex-fiance got an order on her, on Kelsey. Let's go serve an order. The answer?
I don't know if this plays well, because the judge has repeatedly said that, you know, he's not really going to brook any sort of smearing of the officers. And I'm like, ooh, I don't know. I don't know if the judge wants to hear this. So, yeah.
Sounds good. Let's go. Talks to his neighbor. Oh, yeah, I'm the shooter. I'm the shooter. She's a whack job. So you have to take these credibility determinations into account. And I know you're a gentleman, but you have to get down to brass tacks on who's who here, Your Honor. What else shows you that she's a moral person? She doesn't want to involve these guys. She's trying to get rid of them. She says, oh, the guns are over here, so she can go where they really are. She keeps trying to give Houston and Noonan baby things to bring downstairs. She's trying to get rid of them. She's trying to get them away from her. She wants to do this on her own. She doesn't want to have some sort of a situation where she gets shot by one of her colleagues and friends. It's understandable because she's a moral person. She waits for her chance. She gets to her room. There's a distraction downstairs. She doesn't know what's going on because she's focused on the job she's trying to do here, the tragic, awful thing that she's trying to do to herself. That's how you know she's telling the truth, Your Honor. You saw in the room, and I'll show it to you in a minute, the chest that she got the gun from. It's a chest on the floor. It has one of those pretty substantial lids that you would have to flip up to get the gun, locate the gun, pick the gun out of the 4 guns, and stand up. If Noonan was standing right there in the door frame.
I mean, I don't know about pick the gun out of the 4 guns, because there's like all of the guns, and I know this is going to sound a little crazy, but all of the guns in the thing are guns. So I suspect that she probably picked the first gun, right? But I like the argument about the aspect of this is clear that she's got to do some ruffling, right? So obviously Buddy's out of the room. Yeah.
That would have never happened. All those events, that little series of events, he would have been able to stop it. He would have stopped it. It tells you that he's down the steps. He was interested in the distraction downstairs. He saw Kelsey folding some baby clothes, getting baby things ready. His attention, it's human nature. His attention was drawn to go back down the stairs. He walked down the stairs 2 or 3 steps, 4 steps, whatever. And Kelsey told you, straight up, that was my chance. And she took it. And she went in the chest. Exhibit 51, Your Honor. I'll show you right now. She went in that chest, flipped up that lid, got the gun, stood up. She told you, again, she's a moral person. She tried to keep the gun concealed. She made the motion like this, Your Honor, where she put the gun like this, and she kind of walked over here because she didn't want the police to see her with a gun. She held the gun to her stomach area. She walked to a clear area, and she put the gun to her head. And that's what I mean when I say Officer Noonan came back up the stairs, and what did he walk into? He didn't walk into some Rambo woman trying to shoot him in the face. He walked into Kelsey, who you now know a little bit from her testimony. He walked into Kelsey's room, and Kelsey had a gun to her head. and he walked into a suicide in progress, Your Honor.
I find the zooming in on him to be interesting because his face has got some real interesting, things there.
And the man that had just been holding her baby, that she chose to hold her baby, that she chose to feed her baby, walked into her suicide in progress. The gun was nowhere near Noonan. There was no threat to Noonan. And the law says that an officer may not use deadly force on someone who is exhibiting a danger only to themselves. And that's offered to Your Honor twofold, in the sense that it shows that this was not a reasonable use of force, and it shows you that his knowledge of that statute, as he said on the stand, gives him a motive to lie. He knows that this is not a good shooting. He knows this is not a clean shooting. And that gives him a motive here, Your Honor. And like all of us, we all make...
Now, I'm just going to say, I think that this is a good close. I think it's great. I like the close. And I suspect every single word of this is not landing with the judge at all, because I don't think the judge is really... I think the judge at this point is just looking for, is there like something that, is there some major impact that is going to happen? And I don't think that's what we're going to see here.
Mistakes. He overreacted and he shot. He had the look on his face, panic, flustered, he shot. He had made a mistake by leaving her there, walked down the steps, a few steps, and that gave her the chance. And when he did this...
And I think the mistake he made, I mean, quite candidly, I think, my theory of this is that he was willing to leave her for a second because he trusted her. Because he, because they have that pre-existing relationship, he was like, okay, it'll be okay if I leave Kelsey for a minute. Nothing's going to happen. That's my theory of the case, right? That he was like, okay, nothing will happen. It's not going to be a big deal. And then of course it went all super bad, right? So
he knew immediately, Your Honor, that he had to adjust the narrative. Filtered through the legal lens, Your Honor, that tells us that Kelsey had no intent.
Here's the thing. If Noonan shot her to try to save her, he sure didn't need to lie in court on her. The problem is he kind of would, because if he shot her to try to save her, then he's breaking the law, right? Then he's actually violating the law. And if that happens, then he could theoretically be prosecuted for the shooting, right? So if he got up and if his version of the event afterwards was, I shot her to, I shot her to keep her from shooting herself, he could be charged for the shooting. And that is, that's its own thing, right? That's a bit of a problem. So, yeah.
She had no intent to harm Noonan. There's no assault here because she didn't have the intent to do so. As the fact finder, you can consider everything I said about motive, that she lacked any motive to harm this gentleman. In fact, it was the opposite. She thought...
No, shooting at somebody is always deadly force. There's no, I was shooting to wound or I was shooting to help them. Shooting is deadly force. Anytime you shoot somebody, you can kill them. And you don't do trick shots to try to, you don't do like trick shots for any of that.
thought well of him. She knew Justin did this to her. She had just trusted him with her baby, and she had tried several times to get these officers away from the situation. No intent to harm him, no motive driving her mindset to do so. Reasonable doubt, burden of proof, Your Honor. Where the evidence supports a reasonable and more plausible alternative, and that's shown here by Kelsey's testimony, it cannot be said that the Commonwealth has proven their case beyond a reasonable doubt. There is reasonable doubt. When there are two plausible versions of what happened, that itself is reasonable doubt. The versions themselves, Your Honor, show reasonable doubt. Kelsey's version rings true. Noonan's version is all over the place. Noonan's version is contradicted by the strong consensus of everybody else in the house. Noonan portrays a couple different stories, but if you want to pick one where it's this drawn out potential gun battle, where she's backpedaling, sidestepping, tapping, racking, there's commands going on, that takes...
His version of events just doesn't make any sense. Like Noonan's story, I don't find Noonan's story credible. I know guns. I've done the tap rack. I've done all of those things. I've done this stuff under time pressures, not under pressures of like people pointing a gun at me, but I've done it under time pressure. And the notion that she does this twice while backing up as a relatively, younger officer, relatively junior, I'm like, no. I have watched videos of like police in shootouts. And where you see what police do in shootouts. I watched a video of an officer who they pointed their gun and they pulled the trigger. And the gun went click. And you know what the officer proceeded to do? He proceeded to pull the trigger repeatedly. That officer got 0 shots off. He didn't have a chambered round. And the entire, there were multiple officers firing at this guy who was firing back. It was a video of a guy who, he sort of bunkered himself in a domestic violence thing. And so he was refusing to come out, and the officer, he started shooting at officers. Officers started shooting back. But the officer fired, had no round chambered, and just kept pulling the trigger, trying to get it to shoot. Because if you, stuff happens. I do not believe she suddenly became John Wick, right? So
tapping, racking. There's commands going on. That takes time. It takes time for me even to say it. Never mind do it.
I disagree with your assessment that a failed attempt to chamber a round would cause a jam. You can easily jam a gun half racking it. I can't show you. I wish I could show you how to jam a gun by half racking it, but you can absolutely jam a gun by failing to properly rack it. If you pull it back far enough that it pulls the cartridge out, but not with enough oomph to eject it, and then you go forward, you end up with a double feed, and then you're stuck. So you can clear a double feed. It's just a double feed is a bit of a pain in the butt. So in order to clear a double feed, you basically are going to want to pull the bag and then rack the slide repeatedly in order to clear it. There's various ways you can get it, mungled up. You can also get it where you pull it out and it sort of partially starts to move. Lawgirl says, if the chamber is empty, how does it double feed? The point would be the chamber is not empty at that point. So that's how it double feeds, is you get the chamber not being empty and it double feeds. So easy.
And that's belied by everything everybody else in the House says. Everyone else says, Kelsey no, 2 shots in quick succession, bam, bam. That does not fit with what Noonan said happened. So on that alone, Your Honor, as a fact finder, I suggest that your duty is accomplished quickly, because there are 2 extremely divergent versions of this event.
So a stovepipe is something else. You can technically stovepipe with a cartridge, but a stovepipe is something else. So a stovepipe is, you've got your gun. We're just using the finger here, but you've got your gun. And it catches as it's closing on the case, right? So that. Lawgirl says, if the chamber was not empty, why did she need to rack it at all? Could have been a light primer strike. Could have been all sorts of things. If it failed to fire, there's various reasons it can fail to fire, then she racks it. So that it could be, for instance, a light primer strike, a dud round. So then she racks it. So all of these are possibilities.
And Noonan's version has changed itself. Noonan's version is inconsistent with who you now know Kelsey is as a person. It's self-serving. And like I said, it makes him untouchable.
All of these could best don't negate Noonan's story. Noonan's story is largely negated by the whole thing of, it's got this version of her as like really, really skilled, right? So let's imagine that Noonan is chasing after a meth addict, right? And he says that the meth addict gets away from him by getting over a fence. And it's like, okay, how'd he get over the fence? Well, he ran up to it, did a backflip, a triple axel, landed, perfectly nailed the landing, and then kept running. Well, unless this meth addict just happened to be like an Olympic gymnast or an Olympic figure skater or something, we're like, nah, bro, I don't think so. And so, you know, when he's talking about her pulling off all these maneuvers and ducking and weaving, I'm like, maybe she's that good, but I don't think so, right? I just don't think so. So his story is just not plausible because it involves her being really, really skilled. And I don't see any evidence she's that skilled. Like, she's a rookie, she's whatever. If she's that, like, I think Noonan might be able to do it. He's, you know, all this combat badass. He's a SWAT team member, whatever, but I don't know that he could. I mean, they let the prosecutor in close fiddle fuck with this gun all day long. I would have asked Noonan to do it. Hey, Noonan, here's the empty gun. I want to see a tap rack bang twice as you're backing up and diving over in 4 seconds. Here's a shot clock. Beep. Can he do it? I don't know. Maybe he can do it. I don't know. Would a judge ever allow that? The judge lets the prosecutor fuck around with the gun. Now, when we get to the prosecutor's close, I can't show it to you because YouTube is taking videos down for the prosecutor playing with the firearm. So we are not going to, we're not going to do that here. We're just going to do it on audio only. But they let him play all the time with it.
And when you judge it against everyone in the house, he's the only one with the Rambo story. Everyone else has what Kelsey says.
See, Bradle's showing his age. I'm thinking John Wick. Bradle is saying Rambo. But same.
He walks into a suicide in progress. He sees it. He reacts. Kelsey, no. Kelsey, no. Bam, bam. Brain freeze. Mistake. Has to cover it up immediately. What else do we have? When you're a fact finder, Your Honor, you want to look for corroboration. What's the corroboration on either side of this thing? Or lack of corroboration, which is what really it is here. The big one, the big elephant in the room is that this department has no body cameras. We wouldn't even be here if they had body cameras. There's no evidence other than people's words. He said versus she said. That's oftentimes, almost all the time, not a good place to start for the Commonwealth. How many of these guys didn't do reports? What's up with that? Why didn't Trooper Strong put the body camera video on the witness he's interviewing?
Well, because once you record it, once you write it down, you can't, yeah. So, yep.
There's no science. The testimony of everyone else in the house shatters his narrative. Kelsey Fitzsimmons has been blessed. She should be dead 2 times over by her own hand and by the hand of Officer Noonan, who shot too quick. She's blessed. She's here today, and she has a new lease on life. And maybe that's why the investigation is what it is. And maybe that's why Noonan's story is so sloppy, because nobody expected her to be here today, to tell her truth. But she is, Your Honor. And
I mean, she is kind of a fighter there. So, yeah.
And as the fact finder, I want to respectfully ask you to consider the evidence, consider the lack of motive, the lack of intent, the inconsistencies. The credibility contest is firmly in her camp. She came in here and she told you what happened. Unvarnished truth. And I ask you to find her not guilty. Thank you, Your Honor. Thank you.
Yes.
So you might say, wait a minute, aren't we used to like hour-long closes? Yeah, we are with juries. You're always going to be shorter on your close with a bench trial than you will with when you've got a jury trial. Because a jury, you've got to take them through all of the bits of evidence that are key and whatever else. Whereas whereas with a bench trial, they know it. At least this one's paying the troll toll. Bradle is not a good lawyer. He operates off white male privilege. I don't know if you noticed this, Megan. Every cop was a white male. The judge is a white male. The prosecutor's a white male. The only person who's not a white male here in this trial is Kelsey. So if we're talking about white male privilege, you'd think Kelsey Fitzsimmons would have been convicted because she's the only person who's not a white male. So your math kind of sucks. I can't math the math on this one. All right, so this is where we go audio only. Now, I saw some people say, I thought that what he was using in the close was a toy. It's not a toy. You can see here, they are pulling the actual firearm out of the box, out of the exhibit box, and then they are like, and then the prosecutor fiddle fucks with the gun the entire time. It's the gun from the case. And he like waves it around the courtroom. He whatever. Now, I can't show you guys the thing because YouTube has taken stuff down, but I will describe what he's doing. Wait, they used the gun in evidence? Yeah, they did. They did. I've got a goal, by the way, for an experimental drink. And the experimental drink is this thing. I've never used this before. This is an inversion nitro cocktail, elderflower gin sour. So it's supposed to actually have like sour style foam. And it's supposed to foam via some nitrogen canister in it. I've never seen or played with one of these before, but I'm like, I have to get this. It was like $10 at the liquor store. So I was like, huh. The only reason I got it is because I went to get canned Caesars, and I ended up actually buying a different variety of canned Caesar than I normally buy. So this is an experiment with the canned Caesars too. But I saw that and I was like, huh. I'm gonna try it. So that's our next goal is the this elderflower gin sour nitro thing. We're gonna give it a try. Well, and I don't want to press that button. I want to do this. Whose gun was he demonstrating with? Kelsey's. He was demonstrating with the gun from the case. And it is crazy ass. I can tell you, by the way, that if I tried to do this in a trial, I would be told no. Also, like if I wanted to bring a firearm for use as an exhibit, I would be told no. So, yeah. My kids feel left out. Possible you could include an alcohol-free drink for the kids. In the cookbook, absolutely. I will include a few actually. So I will include a few alcohol-free cookbooks or drinks. There's one in particular that I'm going to include that is actually really fun for kids. And the reason why I say it's really fun is that you mix it up, you drink it, and then you try not to spray it everywhere. So yeah, it's a fun one. All right, you just heard gun noises. I'm going to watch that. I can't show you guys what happens, but there were gun noises. Trigger lock is removed. Okay, I'm pretty sure that's somebody checking it, although it happens out of view. So the prosecutor then picks up the item, takes it, and sets it on the prosecutor's desk. In the process, he flags. Let me just watch this again. I got to describe it. He flags his colleague, he flags himself, and I'm pretty sure he flags the officer there. And now they're zooming in on the item. You can see the stippling.
I mean,
Yes.
every piece of credible evidence in this case proves one thing, that she's guilty. All the testimony, the scientific evidence, the physical evidence, the demonstrative evidence, everything points to one conclusion: she is guilty. Even her own testimony proves she's guilty. Because it's impossible to have happened the way she said it. It is scientifically, mechanically impossible for it to happen the way she said it. Her story is that she grabbed a gun, put it to her head, pulled the trigger, and it clicked. The chamber was empty. That's what her story is. And that's what Officer Noonan's story is, too. She pulled the trigger, click, nothing came out. There wasn't a round in the chamber. She even said, she told everybody how stupid I am. I tried to kill myself with an empty gun. But what do we know about the gun? What do we know about her gun? Because after she went to the floor.
Okay, this is a good question. What does flagging mean? So, there's a rule of firearm safety, which is that you never point a gun at anything you're not willing to put a hole in, right? Do not point a gun or allow a gun to point to anything you are not willing to destroy. And that includes if you checked it, if you've left it alone for even a second, you have to check it again. And so imagine that your finger gun is emitting a laser out to the end of where a thing could shoot, right? Flagging is basically if that laser that you're imagining out of this would intersect with anything that you don't want to hit. So, for example, right now I am flagging with my finger the screen and my, thing. But if you take the thing and you go, what? Let's say you're not paying attention and you just now I'm flagging myself, right? Or when I take new people to the range, they sit there and they take their finger gun and they fire the gun. And then they turn around and they're like, that was cool, right? That was so cool. And it's like, no. No. So I warn people that they can't turn with the item, right? They have to set it back down. This is also why when I take a new shooter to the range, the first firearm that I let them use is a Cooey single shot. And the reason why is the Cooey single shot, once it's fired, there is no magazine. There is no way for it to have a second round in it. And then after they have moved on from the Cooey single shot, after they have, after they've sort of shown their ability with that, I'll maybe we're going to try a semi-auto handgun. And what I'll do is I'll be like, here's your semi-auto handgun. It has nothing in the chamber. Here's one round in the mag. We're putting one round in the mag. We're putting the mag in. Here you go. And then they put it at the target They pull the slide back, they let the slide go, they fire once, and then they set it down. And only after I'm confident that they can do these steps without safety violations, without like causing problems, do I say, okay, now we can try loading you like a mag with 5, right? So, yeah. All right, we hit the goal for the experiment. Let's, so this is the can. Nitro flower, elderflower, gin sour. Serve cold. It is cold. Shake hard until the liquid stops splashing in the can. You'll notice that I'm doing a rotary shake as opposed to the other shake because otherwise some fucker would clip this. So we're doing the rotational shake. That's okay. So it doesn't do that. Open gently and then pour straight down into a cocktail glass. Here's our cocktail glass. We are going to open this gently, and it might spill into my lap. All right, that is definitely making a mess. Great. And then it says pour straight down. So that is, oh, what? I was going to say it was kind of underwhelming, but it is forming some thing. It's got a little foam on the top. It's not like super, but it is very purple. Oh, it is foaming up a little bit more. So, nice. Yes, it's a nitro drink. This is like very EDB colored. I feel like EDB needs to try these because these are very much her color. So yeah, it's actually really good. Tastes really nice. So yeah. Okay, back to the prosecutor.
Lieutenant David picked it up, put it on the bed. Officer Noonan picked it up and put it on the table. And then Officer Core came in the room. And what happened then? Officer Noonan said, secure that gun, make it safe.
So here's a thought. There's various innocent ways that that could happen, right? There's various innocent ways that, because one of the things he's saying here is, how did a round end up getting into the, into the chamber of the gun? It's real possible that, like, if you imagine Noonan here picks the gun up, he could absolutely rack around into it as he's, because like Noonan is like, I moved the gun. Okay, but did you move the gun and did you rack around in it while you were moving it? Because that could have happened. Somebody said, are we supposed to be seeing video? No, we are not. And the reason why we're not supposed to be seeing video is because the prosecutor waves a gun around and that will get this stream nuked. This stream will get taken down because several other people have had streams taken down because the prosecutor was very, very.
And so
casual.
what did he do? He took the gun. He found that black box, the safe. He made sure that was empty. He turned it over. He pulled out the magazine that you can see right here. He opened the chamber, and there was a round in the chamber. He dumped it out into this safe and put the firearm in there. And then they stood watch on that until State Trooper Bonasara took it back in the lab.
But they had so much time while they weren't being filmed. They had so much time that they could have, for instance, said, hey, this story doesn't really work very well. This story's got a problem because there's no round chambered. Why don't we chamber around? Right? There's so much time for that.
That magazine that you have in evidence contains 16 rounds. It was a 17-round capacity gun. It contains 16 rounds, plus the one that was in the chamber.
Right. Okay. So 17 full mag.
17 rounds. As we know, there are only 2 ways to get a bullet into the chamber. One is if there's already a bullet in the chamber.
Wait, that's not a way to get the bullet in the chamber. That's just... There's 2 ways to get food into your stomach. One is you already ate. And then 2 is you eat. And I'm like, what? What? Huh?
Pulls the trigger. A bullet comes out, the casing comes out, the chamber's open, the spring allows another bullet to come out. That's one way, and we know that didn't happen here. The gun didn't fire because the chamber was empty. The only way a bullet gets in this chamber, other than that way, is if someone racks the gun. She said she didn't rack the gun, but there was a bullet in the chamber. She did rack the gun.
Or somebody else racked the gun. By the way, the entire time he's doing this, he's using the gun as a prop. So the entire time he's holding the firearm.
What did Officer Noonan say?
Now, in fairness, he's holding it and he's pointing it at the wall. So, yeah.
She pulled the trigger.
And now he just pointed it into the corner of the room. Thankfully, there is nobody in that direction. So he is pointing it in a safe direction. And he's pulling the trigger. Why do you need to use this as a prop?
Nothing happened. She stepped back, tap racked, tried again, didn't do it. Tap racked again, pulled it. And that's when he fired. She put a round in that chamber. That's the only way it got there. Her story can't be true. She got up on that stand and she lied to you. It's science.
By the way, when he set it down, now it's flagging the court staff. So, I am not cool with that. What is it? Wolf Lover says, I was taught not to dry fire a gun. That really only applies with 22s. You can and possibly should dry fire other firearms because dry fire is great practice.
Scientifically and physically impossible for her story to have happened the way she said it.
Yes, he did.
That's what the evidence shows.
Can you pull the slide, place a round in it, then slowly release the slide without it going off? Yes. Although you should just release it fast. So, yeah.
But she didn't just lie to you then. She lied again. She lied at the scene about where the guns were. And I'm not, and she admitted that, and I understand that, right? And she said she lied to the police because she decided to kill herself.
Let me see if I can make myself sufficiently big to avoid a problem here. We're going to give it a try. All right. Yes, I am just big enough. Yes. So right here is where the item is there. And it's blocked because I made myself slightly bigger. But the reason why I'm showing you this is I want you to see the judge's face. The judge is making a face here. And the face is like, I'm not finding this super awesome. Now, in Canada, we have a rule, and the rule is called the rule in Brown and Dunn. And so the rule in Brown and Dunn basically says that if you want to rely on a competing theory of events, then what the witness tells you, you are required to challenge the witness with it. You are required to, you're required to present it to the witness. So, if this was in Canada, this closing argument from the prosecutor would be absolutely getting flamed. I would be standing up if I was the defense and this was a Canadian trial and just going, I hate to interrupt my friend's close, but Brown and Dunn is a problem here. And I'm just putting the thing there, Brown and Dunn. So basically it means that if your theory is that she racked racked around in, and you want to argue that she didn't rack around, like that she says she didn't tap rack, you want to argue that she did tap rack, and she gets up on the stand, you have to say, you racked around in, didn't you? And that lets her say no, right? It lets her explain it. It lets her, and then you would say, how did a round get into the chamber if you didn't rack it? And she can try to explain it, right? She can. And the thing is that this would actually have been a more effective cross-examination, because at the end of the day, I don't know if she could explain it. I don't know if she can't explain it. But let's envision that she can't explain it. Let's envision that she's going to sit there and go, I don't know. Well, then that's great on your cross, right? They might have been able to actually hammer her on this cross, but they didn't. Somebody asked, how strong is this drink? It is 10.8%, so not super strong. And it's a 250 milliliter container, so not a lot of booze in there.
But when did she say she said that? They had been to the house. They had talked to her, according to her. She now started contemplating all of the ramifications of what's going to happen to her. Because she's losing her life, or her.
I think he didn't ask her because he doesn't want her to explain, because if she explains, then it might ruin his argument here, right? I think he found that she was way too believable, way too credible, and way too honest, and that he did not want to take a swing at her, because he was worried that if he took a swing at her, she was gonna knock him down. That's what I think this is he didn't want to ask the questions because he thought that she was going to, gonna smack him down. Now, I see people keep asking why no things, so we're going to put a banner at the bottom. Prosecutor keeps fiddle fucking a gun. There we go. So there's our banner. Just to explain things. All right, here we go.
Job, her son is being taken away, all of these things. And so she's going that over her head. And then minutes later, as she's walking through the house, she says, my gun's in the basement. Because that's the time she made the decision to kill herself. Later on. And we know that's a lie. We know that's a lie because what was one of the first things they asked her when they went to that house? They asked her to put the baby down because they were concerned for the baby, told her the restraining order, what the parameters were, and asked her where your guns are. When she was still sitting on the sofa. They weren't waiting to ask that question until she was already walking around the house. No way. And what did she say there? They're in the basement. And we know she said it there before she moved around the house, which is untrue, because her friend, Officer Houston, was invited.
I'm watching it on the Boston NBC 10 news channel. The thing is that news networks get flagged with different rules than like commentary channels like mine. So the commentary channels like mine, we get, you know, if they see a, a thing, they hammer us. News channels, they can show guns all the time on a live thing, and they're just fine. So it's different rules.
Invited to her wedding says it also. He says, Sergeant Daly asked. And then remember what he said? He said, I was in the living room, she was sitting down, and then I saw a gun case on the other sofa. And so I opened it up to see. And she said again, I already told you the guns are in the basement. Now, why at that?
So he's relying heavily on, she lied to a police officer, so surely she's going to lie in court. Yeah.
At that point, did she say that? We don't know. She didn't tell us because she lied to us about why she said it later, because we know she didn't say it later. So she lied again. You can't trust her. She also lied about knowing that her mom was in the house. She was upstairs. The officer, Noonan, I think it was, Noonan heard an older woman's voice down there and said, who is that? She says, I have no idea. She doesn't know her own mother's voice, her best friend that she just talked to come to the house.
She might not have been able to tell who the voice is because she's up fucking stairs. Right? She's upstairs. She can't hear her. You know, she's probably hearing it as like, like, okay. And this is the other thing, is she also might have said, I don't know who that voice is. Go fucking look. No idea who that is. Go look. I just need to be alone for like 2 minutes. Please go look.
And she said she didn't know whose voice it was. Another lie. She said on the stand yesterday that she didn't know Justin was in the house. And we know that's a lie too, because what happened when the three of them were upstairs? It's Noonan, it's Houston, and it's the defendant.
And Noonan also said he didn't know Justin was in the house. So is Noonan a sack of shit too?
She hears him downstairs. Houston hears him downstairs, and she says, keep him away from me. I don't want him in my house, or something to that effect. And that's when Houston went down to make sure he wasn't coming up and went to the basement. She knew he was in the house. She absolutely did, and she lied to you when she said she didn't yesterday. And you know what else she lied about? Something so simple, but it shows who she is. The restraining order. She said the restraining order was taking my dog away.
This nets an objection because apparently it's not actually true what he's representing to the court right now.
It says it. It doesn't say that. Nothing about the dog in there. I could go on about the lies, but I want to talk about the credible evidence. The credible evidence in this case. When Lieutenant Daly got a call, I actually got a visit from Justin Elaine when he was in the lobby of the PD. And Justin told him he got a 209A against Kelsey Fitzsimmons. And Detective Daly knew that she had been sectioned before, that she had guns, that they were taking the child away from her for a period of time. And so what did he do? He called Officer Houston. He asked Houston to call Daly to meet up. And why did he say he did that? He said because those two are cool, calm, and collected. They don't panic. They keep things calm. That's what he said. And that's why when he called Houston, he said, can you call Daley, we gotta do this. And so he wants you to believe, defense counsel, that Pat Newman was cavalier about, oh, okay, sounds good.
Like maybe cavalier about handling a gun in court?
We have to serve a restraining order. But that's not what happened. He was mischaracterizing it, I hope you remember, in the grand jury minutes, because Houston had called Pat and said, hey, we got to serve an order. Can you meet me by the school? And Pat said, sounds good. It wasn't until he got over there, it wasn't until Lieutenant Daley was there that they learned really what they were going to do. And they went over there. And defense counsel asked Daley, you guys were cavalier about it, you knew her, weren't worried about the guns, all this stuff. And Lieutenant Daley said no. No. His quote was, we had an increased level of diligence. Everyone was more on point because they did know what they were walking into. They did know. They did know that she had been sectioned before. They did know there was going to be a baby in the house. They did know that she had guns. They did know at that point that she had parked her car far away. This is all going to what they were thinking at that point. They did know all those things. And they did know Justin's concerns. He said, according to Lieutenant Daley, I'm worried she's going to kill the baby, kill herself, and kill someone else. So that's what they were thinking when they went into this house. That's the credible evidence when they went in there. And what did they do when they went in there? They sat her down, and they allowed her, or maybe they asked her, I can't remember, to go around and get some stuff for the baby, because she knew Justin was coming to get the baby. And they were in her pocket the whole time. They followed her around the house, at least two of them, while she did that. And you know that because even Officer Houston said, I was in her pocket. We went into the kitchen, and I noticed there were butcher blocks with knives on it. With knives in it. And they were...
This is the kind of testimony that honestly should result in, like, if I'm a judge and a police officer's like, I went into the kitchen and I noticed that there were butcher blocks with knives in them, and I found that very concerning. It's like, every fucking kitchen has knives in it. I would actually find it very suspicious if I went into a kitchen and there weren't any knives in it. Like, come on. So the pew pew is still on the table. It is within full view, and the AI may spot it as being, in full view. So, yeah.
Concerned. There was no chance they were leaving her alone. No chance they were leaving her alone.
I mean, they could have, but they didn't. Yes, it is. He leaves it on the counter in full view. So it's just sitting on counsel table in full view.
Officer Newman. All of the testimony that you've heard about Officer Newman, even from the defendant, he's a gentleman.
Yeah, but this is one where at least two people have had their streams taken down. So I am being very cautious because I don't want to get a 24-hour ban again. Especially because I've already had my 24-hour ban, so I might actually get a strike if they do it. And if I get a strike, then I'm down for like 90 days. So, yeah.
He's experienced. He is by the book. And his training and experience starting in the military, through boot camp, through security forces school, security forces squadron, with all the training he had, and Humvees and helicopters, and the SWAT team, 2 times a month training, clearing rooms, clearing buildings, hostage situations, missing persons.
And he could still have fucked up in a very, awkward, difficult position. So, yeah.
Shoot, no-shoot scenarios twice a month and a 40-hour block every year. For over a decade, he did that. And he moved to Lawrence.
And he still missed a shot at 3 feet, according to him. So, I mean, maybe he's Billy Badass, but it's still 3 feet. Can you apply for a gun-approved channel? I will talk to my YouTube dude, but I don't think they will set that.
As far as the department goes, because it was busier and he had more experience. He was cool, calm, and collected. There's no doubt about that. And to say when they're upstairs and he walks away and leaves her alone because he heard a commotion that Officer Houston was going to attend to is a joke.
I mean, it might be a joke, but it also might have happened because, like, seasoned officers, I hate that they're coming at this from this perspective of, like, they're coming at this from this perspective of, like, the officers could not do wrong. And I'm like, but they could, though, right? They absolutely could. So let's not just assume that, we can't just assume that the officers are, like, infallible.
It really is. Now, how do you know they were going by the book at that point? And how do you know they were vigilant? Because they followed around everywhere. Because both Houston and Officer Noonan said she kept handing us things and we kept putting them down. We wanted our hands free. Because they were ready for whatever happened. Hoping nothing did, but ready for whatever happened. So at some point, Houston and Noonan are upstairs and the defendant goes into her room. And she hears Justin. And Houston goes down to keep the peace to make sure he's there. And Officer Noonan is watching her. He's watching her. And she's on one knee. And she lunges and she disappears. And she emerges with this, pointing at him like she is trained to do.
He's fiddle fucking the gun again.
Click at his face. And what does he see next? He draws his weapon.
The gun is not a toy. The gun is not a prop. Put it the fuck down. I hate this. If I tried to do this in a courtroom here in Alberta, the judge would have me in fucking iron. Not in, not like finish my clothes. It would just be like, yep, you get to wear some metal for a bit.
And he says his testimony, it kind of slowed down. The whole thing took maybe 4 seconds, maybe even 3.5 seconds. His training has kicked in. His experience has kicked in. It was a surprise to him, certainly, because she got the drop on him. And why did she do this? Who knows? Maybe he's right. Maybe she was going through him to get to justice. Maybe she was just so upset she was going to shoot anybody in front of her. Maybe she wanted him to shoot her. We don't know because she lied about it. We don't know. But the fact is, she started to shake, she started to tremble, and she lunged for the gun that he couldn't see. And what happened after she flipped? She stepped back, and now he knows, based on his training experience in the clip, there is not a round in the chamber. He knows that, and so he doesn't shoot. According to the defendant's testimony, he had every right to shoot at that point. And you know what? He actually did. He had a right to shoot her at that point. If you point a gun at a cop and pull the trigger, they get to shoot. But he didn't. Because he was controlled and disciplined. That's the way his career went.
He was such a hero, and isn't he handsome? And he's got a 12-inch dick, and it tastes great, is basically what this prosecutor is arguing at this point.
And so she steps back, tap, crack, and tries to do it. He doesn't shoot her then. And what's he doing at this point? Kelsey, no. Kelsey, no. Because he knows the threat isn't there, really, because there still wasn't one in the chamber. Kelsey, no. Kelsey, no. He is being disciplined like we wish every police officer, every law enforcement agent in this country was. He should be applauded for his actions on that day.
Let's throw him a parade. Let's give him a hand job. I mean, come on, dude.
Tap rack again. Now he knows one's in the chamber.
How does he know that? How? Come on, dude.
That's on. She starts to raise it, and he shoots. He shoots twice to stop the threat. He stopped shooting when the threat was neutralized. Defense counsel, during his cross-examination, well, you would have unloaded her gun. He goes, no, that's not what you do. You shoot until the threat is neutralized. She was now down on the ground. But his training and experience are still taking over at this point, because what does he do? He still has his gun on her, because the gun's still there. You can't see it.
So the threat isn't neutralized. Your own clothes contradicts your own clothes. Oh my God.
Lieutenant Daly comes in, Lieutenant Houston comes up, and what does Officer Houston say that he sees when he comes upstairs? That Officer Noonan is standing there with the gun low and ready. His training is still taking place. He's still doing what he was trained to do. The gun is put on the bed. He's calm and collected. He takes the gun and moves it away so people are safe. He's deliberate in those actions. When it's away from her, he starts to tend to her. Officer Core comes in, and he asks Officer Core to make the gun safe. He's cool, calm, and collected. That's what Lieutenant Daly expected, and that's what he was. He didn't make a mistake. That's what the credible evidence shows. And what did he say to Officer Houston after? And this just goes to state of mind, I know. That she pointed the gun at me, and it clicked. And she tried to rack him up. Immediately after, this wasn't him saving his hide or protecting himself. Seconds after this happened, that's what he said. Every piece of credible evidence points to the unmistakable fact that she is guilty. Every piece of physical evidence, scientific evidence, mechanical evidence, every piece of testimony from Daly to Houston to Core, even Lauren Page, the mother, even the defendant corroborates what Officer Newman says. Every piece. Your Honor, I would suggest to you there is only one fair and just verdict in this case, and that is guilty. Thank you.
And spoiler alert, he gets fuck all.
Maybe we approach sidebar.
I'd like to speak with counsel anyway at sidebar for scheduling purposes.
All right, so they go to sidebar and then they come back.
Counsel table. I'm just going to. We went to sidebar for two reasons. One was Mr. Bradel has a series of objections that he'd like to lodge about the Commonwealth's closing, which
So training says you empty the magazine, reload, and maybe empty again. You don't shoot once and approach the threat you don't know is neutralized. This training has failed if we follow Commonwealth logic. I mean, the thing is you shoot until the threat is neutralized. Just because she's on the ground, when you don't know where the gun is, the threat is not neutralized at that point, because at that point, as far as you know, she's about to pop you under the bed. Right? At that point, as far as you know, she is going to, turn under the bed and pop out your kneecaps. And then as soon as you drop, she's going to pop you in the dome. Right? So, I have some anger. I have much anger. Here we go.
I'm going to give you an opportunity to do in open court with the Commonwealth in open court responding. And also, I went over the schedule. So as I told counsel, my intention is to take as long of a period of time as I need to reach a verdict, provide the court staff and counsel with 30 minutes notice. And
I really like this. He's like, I don't care how long it takes. I'm going to think about this as long as I fucking need. Fuck you. Good.
Come out and announce my verdict, some of my reasoning here in public, and whatever time that works. In other words, if it's during our traditional lunch break, so be it. You folks will have a half-hour notice, which means that you'll be able to go and have coffee or lunch or whatever, as long as you can get back here.
He's like, if I call you and it's lunch, put down your fucking sandwich and get out here. I can get behind that. I'm okay with that.
All right, so that's how we've worked that out. We also discussed at sidebar the fact that in a jury trial, we never provide the jurors with ammunition and a firearm, even with the trigger block.
Because some moron in the jury room would be like, well, I'm going to try to experiment with this. I'm going to see about what happens if can I tap, rack, bang that fast? And they're going to put a hole in the jury room and they're going to end up like, so you don't let them ever have a situation where they've got a gun and ammunition, because jurors are dumb. And he's like, I am not dumb like a juror, but I'm also going to follow juror rules because we're just going to play safe.
At the same time. So my intention is that Mr. Ruane, our assistant clerk, will keep possession of the ammunition, and the firearm will come back in chambers with me, along with the other exhibits. When and if I need the ammunition, will be switched out.
If I was the judge, I'm like, I'm going to take the gun and I'm going to take the ammunition and I'm going to the range. See y'all tomorrow. It's like, I'm going to play with this. I'm kidding, but yeah.
All right. Okay. Globally, have I said in open court what we discussed?
Yes.
Okay. All right. So, Mr. Bradell, I'll hear you on the objections.
Thank you, Your Honor.
So, Judge, traditionally we do this at sidebar, but as you mentioned, we don't have a fact finder here that we need to talk off to the side to. So, in open court, I'm happy to do this. Sure. Yep, I'll go back over everything I said at sidebar, Your Honor. Judge, the first.
So normally we have a sidebar, because the jury's not allowed to see the sidebar, but there's not much reason for it because there's no jury. It's the judge. So yeah. Fuck, I nearly got hit by a car. Some idiot drove through the pedestrian crossing when I was in the middle. I'm really glad you are not the driver of that because, that would be concerning.
Objections I have to counsel's closing argument center on ballistics issues. The first part is that counsel picked up the gun and used it 3 times. Prior to that, counsel provided what I would consider to be expert testimony on the operation of the gun. I think it exceeded the scope of what Detective Bonasaro talked about.
I would agree with that. I think that they testified to things, or that the prosecution, I think the prosecution knows guns at least a little. I don't know if he knows them a lot, because if he knew them a lot, maybe he wouldn't fuck around with the gun in the courtroom. But I think he knows them at least a little. And the problem that the prosecution reaches here is that the prosecution knows guns better than the judge does, and says, like, we know X. And the judge is like, I don't know X. X is not in evidence. Go F yourself. That's not how that works. You don't get to. And so part of why they lose, I think, is that they fail to successfully cover that. I also need to ask a question of the chat. This is a question before I spend a whole pile of money for something you guys may not want. Do you guys know what challenge coins are? Chat, do you guys know what challenge coins are? Yes, no? Is that something you're familiar with? I see a lot of yeses. So I am currently looking at getting some challenge coins made. I see some people saying no. So I'll show you guys what a challenge coin is. Oh, I've got a whole fuck ton of them. I'm like, oh, I'll pull them up online. I will, and I'm like, I don't need to do that. I've got a bunch of challenge coins right here. So, well, not a fuck ton. I've got a few, and I've got some more that I got to put in here. Yeah, I got a bunch. Why are these not in the case? They should be in the case. So, and now that I've handled it, all right. So I've got this extra life thing is not really a challenge coin, but it's kind of a challenge coin. I got given this one. I think it's really cool. I got a challenge coin for the Office for Bombing Prevention. That was given to me at SHOT Show. I've got a challenge coin for Combined Forces Special Enforcement Unit. That is really cool. I got one for the Canadian Coalition for Firearms Rights. Laclabish County Enforcement Services. These kinds of things. So basically they start from a tradition from military stuff, but they've grown beyond that. They're not just a military thing. They're kind of a collection thing. So I got to decide if I want to buy some challenge coins. And what I'm thinking for the challenge coins is basically that I will order 2 kinds. And the first kind will be just plain metal, right? So they're not going to have any fancy enamel or anything like that. And those I'll probably put up for sale at like $25 if you want to buy a challenge coin. So you could buy a Runkle of the Bailey challenge coin that is just like plain metal for $25. The other kind of challenge coin would be with enamel. So it'll be a nicer challenge coin. And the challenge coins will be, those ones will not be purchasable. They will not be for sale. They will just be, the way you get those is you earn them or, something like that. So, will $25 cover shipping? I will probably have to look at what shipping is. Earned. So I will send Tide a challenge coin, like an enameled challenge coin for you've earned it. But for others, I might I'll send Ramos like an enameled challenge coin and just be like, hey, I don't give these out. So, but for the challenge coins that would be purchased, would you guys have any interest for the purchased ones? Because there'd be two kinds, right? There'd be the ones you could buy would be kind of like this, where it's just metal on metal, right? The other kind would be more like this, where it's got the enamel thing. So minimum orders are 100. And so I'd end up having to order 100 of them. And if I order 100 of them, they are, it's like $1,500 worth of outlay for 100 of them. So, it's a fairly big thing. So, yeah, I just kind of gathering as to whether or not somebody would want it. I don't know. I got to figure this out. All right, let's go back to the objections. We can actually show the screen now, and we can embiggen the screen. Here we go.
He said that it had to be a scientific certainty that this gun was racked by Kelsey Fitzsimmons. Mischaracterizes the defense position that we're not saying necessarily that it didn't happen. We said that Kelsey Fitzsimmons didn't rack the firearm. And
well, why?
And we have.
Why did that? Jaded for Justice, loved you on Defense Diaries today. Thanks for explaining everything in the classic Runkle way. This goes towards the new computer and investing in some more cameras. I love the challenge coin concept and we'll definitely get one. By the way, is Rob doing okay? Rob is, I don't know if doing okay is the right thing. He's got life stresses, right? Life is kind of kicking Rob in the ass right now. And he is doing the best he can with that. And, but he's going to be okay, right? If that makes sense. He's gonna be all right. But, right now he is, he's got to deal with other shit. Also, so yeah, Rob's just got family stuff. I don't want to go too much into Rob's stuff because it's Rob's business, right? And so if I tell you what Rob's got going on, then I'm breaking, like, Rob tells me shit, but I don't know if I can tell you the shit, right? Like, I just don't know. So that's kind of the concern, right? This is fair. Have you finished mailing out the items? I'm getting real close. I have almost got all the items mailed out. So, Rob will be okay, right? He will be fine. It's just he's not fine yet. Will I do a Friday Night Frenzy tomorrow? I will talk to Mrs. Runkle. If I do Friday Night Frenzy tomorrow, I won't do Monday. I can only do one because otherwise I will just be like, whatever. So I'll do one of Friday Night Frenzy or Monday. But yeah, we'll figure that out. Yeah, attorney bestie confidentiality, 100%. So I hope that he'll be able to give updates soon, but the updates are really his business. So
a completely different version of events. So no one's saying that it didn't happen. We're saying that Kelsey didn't do it. And to characterize it like, that it had to be racked by Kelsey Fitzsimmons is not fair argument, and it mischaracterizes the state of the evidence.
I'll do Monday then. I see people saying Monday. We'll do Monday.
The second objection relative to ballistics, Your Honor, is that counsel was acting out. I believe it was the second time he picked up the firearm. Counsel was acting out on Noonan's story that Ms. Fitzsimmons had accessed the firearm from the chest and picked it up to point it at Noonan's face. And on Noonan's testimony, she just pulled the trigger and it clicked. Counsel's acting it out. Prior to pulling the trigger, counsel racked the firearm and then pulled the trigger. And that's not what happened on even Noonan's testimony.
I'm happy to allow you to make a record, but the fact that there's two different versions of what folks testified about is fair game.
But it's not that there's two different versions. That this is a third version that is nobody's version.
The issue right now is whether the Commonwealth argued items that were not in evidence or attempted to draw inferences from items that were not in evidence. So the disagreement about the racking is just not before me.
Well, that's why I bring it up, though, Judge, because this racking issue has been brought up to the forefront, and he did something that is not part of the evidence. No one says that she racked the gun before the first shot, and that's what he did when he acted it out. So that's why it's a mischaracterization. I'll just rely on Your Honor's discretion.
But that's not what Mr. Kubatosi did, though.
I did see him rack the firearm before he fired the second shot. He did it the second time, Your Honor.
Okay, I'm having trouble understanding. Again,
it's just that when you act out the testimony, you have to do it accurately, and he did.
I'm going to say this in open court, and it won't be.
So I'm seeing people say they're not so keen on the challenge coins. I do need to get these up on my store. These are Pigeon Business pins. So these I got to get up for sale. I got to get these out of my house. I got to get these for sale. I've had these around. So Pigeon Business pins. So that I think I got to put up for sale, and yeah. So we'll do that.
The last time I say it, whether or not Officer Noonan exercised reasonable use of deadly force is not before me. That is not my decision.
I agree with you, and I say it on credibility.
And hold on, and whether the North Andover Police Department followed procedure in executing, serving this restraining order is not before me. Child custody is not before me. All right, visitation is not before me. What's before me is, has the Commonwealth proved beyond a reasonable doubt that the defendant pointed that firearm for any perceptible amount of time at Officer Noonan? Okay, so all of this is just not helpful.
So the Pigeon Business thing is based on this. And basically what I was commenting on is there's an old adage that when you play chess with a pigeon, the pigeon will just knock over the pieces and shit on everything. And I then applied this when I was discussing a particular lawyer. I'm not going to name the lawyer, but you might be able to do the math. There's a particular lawyer I was discussing, and one of the things I was saying is that sometimes it can be very difficult to identify whether there's this thing that makes me nervous as a lawyer. And the thing that makes me nervous is that when somebody makes an argument and I look at the argument and I'm like, this argument is complete dog shit, right? The other side makes an argument and it's complete idiotic shit. And you go, okay, here's the thing. If I think a lawyer makes an argument and it's just a bad argument or a weak argument, I'm like, okay, let's go to town. But when a lawyer makes an argument and I'm like, I have no fucking clue what they're doing, that's when I get very nervous. And the reason why is because there's basically one of two outcomes. Outcome one, the lawyer is doing a stupid thing. And that is like 95% of the time, right? But 5% of the time, the rest of the time, the problem is that I don't know what's about to hit me, right? So when you get an argument that is just so fucking ridiculous, you can't tell if it's like genius that you don't understand or if it's just pigeon business. So, pigeon business, we use this on the channel just for the times when something is so fucking dumb that it takes us to this place where we're like, this is so dumb that I don't know if I'm like that. I'm concerned about whether or not this was, this is something else. The other thing about the pigeon, you can't see it all that well. It's actually like white and black. It's just that it's got a protective layer. So like I'm not peeling the protective layer off because I'd probably want to send this to somebody, but this pigeon is wearing sunglasses and also has a backpack. And the reason why the pigeon has a backpack is because we also covered a case where somebody trained pigeons to fly into prison with a little pigeon backpack in order to deliver drugs into the prison. So it's kind of a mix of all of that. So yeah.
I offer on credibility, though, Your Honor.
Okay.
I have not gotten Rob's pigeons to him, but there is a possibility that I will be soon able to deliver the thing in person. Why don't you look at the camera? So the reason why I don't look at the camera all the time, I have on this screen here the trial. So when I'm watching trial, I can watch it here. But on this screen here, I have my stream management stuff, including the comments. So when I'm reading the comments, it's over here. When I'm watching the trial, it's over here. That's how that goes.
Also, the Commonwealth said that.
What? What do you mean an error occurred?
Is not before me. What's before me is, has the Commonwealth proved beyond a reasonable doubt that the defendant pointed that firearm for any perceptible amount of time at Officer Noonan? Okay, so all of this is just not helpful.
And I offer on credibility, though, Your Honor.
Okay.
Also, the Commonwealth said that at the scene, Ms. Fitzsimmons didn't say part of her story there, so therefore she's making it up. And whenever the Commonwealth tries to argue that somebody, a defendant, didn't say something, that's very dangerous ground for the Commonwealth, Your Honor, that the defendant is under no burden whatsoever to say anything, Your Honor. And here to suggest that she's lying because she didn't say part of her story when she's shot in the chest at the scene is unfair argument, but it also violates her right to remain silent.
So the thing is that there's a bit of a different scenario here, right? Where somebody comes in, like think of the Hannah Gutierrez Reed scenario, where the person comes in and gives basically a full account of what happened, right? They show up and they say, okay, so I got up, I had breakfast, I like watched TV for 20 minutes. And then, I heard a knock at the door. When the knock at the door came, all of this stuff, right? And they tell you every moment of the day, every moment of the thing. Then you can possibly draw an inference from something that they didn't, something that they didn't say. right? Because if they say every little moment of this interaction, but they, imagine imagine somebody kicks down my door right now and I grab a knife and I fights them off, right? With my, you call this a knife? I fight them off with my knife. And so later, after I tell the story, at trial, I recount the story again. And for the first time, I mentioned that person was armed with a flamethrower. And I've never said that ever before. I hit them with my knife because they had a flamethrower, and I never mentioned the flamethrower in my previous thing. Well, then they might say he probably didn't have a flamethrower because you would have said that, right? But if instead somebody comes in with a shotgun, shoots me, and I manage to get a knife and throw it at them and they die, and the police come in and I'm there and I'm I've got a big shotgun hole in me and I'm whatever, I was defending myself and I don't give a full story. Well, then, that's understandable. It's not a full account of things. So, yeah. My girlfriend told me I can't buy the flamethrower robot dog. Did she say you can't buy the flamethrower robot dog for your favorite YouTuber? I suspect not, because that thing's like 10 grand.
And it's an intrusion on that, so I would object to that. I ask you not to consider that, Your Honor.
Oh, some people are asking about the ouchie stick. The ouchie stick is missing a tooth. So, yeah. It's still there. It's missing a tooth.
That Mr. Bradle, she waived her right to remain silent, right? She testified. So
at the scene, though, Judge.
Isn't it fair game for the Commonwealth to discuss the testimony that your client offered?
The testimony, yes, but he's saying that at the scene, she didn't say XYZ when she didn't have to say XYZ at the scene. And that's, the Commonwealth can only argue that when a defendant makes a comprehensive statement and leaves something out.
Okay, first of all, I should be showing you the video, but second, it cuts out here in the middle of his argument for no freaking reason. So the missing tooth story is basically I was using the ouchie stick on screen. Those teeth are glass. They're volcanic glass. I bumped the thing on something and it broke off. So yeah, that's how that was going. So yeah. All right.
That you wanted to kill someone else, which didn't happen. That was not the statement. So that's a very important, very dangerous, very unfair, very prejudicial misrepresentation of what was attributed to Justin Elaine in the lobby. She never said anything about killing someone else. He didn't even he didn't say that she said that. So I ask you to strike that and not consider it. And the last thing, Judge, about lying about the dog on the restraining order, Your Honor, that trying to take her dog. And it is in the complaint to the restraining order by Justin Elaine.
I know he's trying to do a second closing, but the evidence is what the evidence is.
Yeah, but Judge, you can't say, when you have the discovery on the point, you can't say that something is a lie when you have the papers that show it's not a lie. And the box was checked in the complaint to get her dog. So that's a mischaracterization of the evidence that needs to be corrected, Your Honor.
And yeah, he's like, the prosecutor just basically straight up lied to you. Wow.
And that's my last point. Thank you.
So So, Commonwealth, from my perspective, with all due respect to Mr. Brado, who's done a terrific job advocating for his client, I view that as nothing more than a rebuttal to the Commonwealth's closing. So I'll give you a few minutes to rebut these things. Let me say this, though. I don't believe that there was any evidence before me that Miss Fitzsimmons was sectioned previously. I think that the way I view the evidence is that this is what the police believed. It was part of their state of mind in serving it. But I'm at a loss, frankly, that, in other words, what I'm saying, Mr. Bradle, is out of all the items that you argued about the Commonwealth purportedly arguing something not in evidence,
Yes.
this sectioning, alleged sectioning that happened prior to this,
Yes.
there's no evidence of that before me. There's mention of it, and it goes to the officer's state of mind. So, and that's all that in fairness, that's all that you argued, Mr. Gubitosi. But I guess what I was getting at is if there was anything at all that came close, that would have been it. But Mr. Gubitosi, I'll give you a few minutes for your rebuttal to the rebuttal.
I don't think I trust you to have sifted through what's relevant, what's not relevant. The evidence is what the evidence is. Closings
This part is actually kind of funny, straight up.
are not evidence. I would suggest to you that, yes, I do concur there, that I argue the evidence that came from the witness stand and from the exhibits to Ravanasaro absolutely describe the ways that a firearm works and how a round gets into the chamber, and I limited my explanation of that to what he described.
No, you didn't, and the judge is going to call you on it. Runkle, should he have objected during closing? The judge missed every point. Normally, unless something egregious happens, you don't object during a close. And I would say during a judge alone thing, you should probably not be objecting during a close and objecting afterwards instead. Because if you object during a close, the only time I would say that you want to do that is if the other side is saying something so egregious and so prejudicial that there just isn't a way to fix it and that you absolutely need to preserve it. So, I mean, let's consider the most ridiculous possible example here. There is a lawyer. There is a guy that the Law Society is allowing to be a lawyer in Canada who has previous convictions with respect to child offenses. I'm not going to be any more specific than that. Child offenses. And so if I was up against that lawyer and in closing arguments, I was like, and what the opposing counsel isn't telling you is that and I talk about the opposing counsel and like him having proclivities with kids, they would absolutely object to that right at the moment, and they would ask for a mistrial and they'd ask for sanctions. But yeah, I don't think that guy should be a lawyer. That's my take. But yeah.
And the like.
Oh, I also see that we hit the goal. So I got these. These were also, I think they were $12.50. This is not a sponsored thing. I paid for them. I don't get any cut. But they had these little cans of 5% Caesar beverage. And I was like, I'm going to try it because most canned Caesars suck. Now, people are like, what is a canned Caesar? Well, ingredients: water, ethanol, glucose, tomato paste, salt, seasoning, vinegar, molasses, caramel, garlic, sucrose, spices, tamarind, natural flavor, maltodextrin, red peppers, clam nectar, disodium inosinate, disodium guanylate, Allura red, So a Caesar is Clamato plus vodka, except that because it's in a can, it's also got a whole bunch of other ingredients. But it's a Caesar in a can. And all right, I see people like losing their mind over this. I am going to try to find a bar in... So May 29th or 30th, I haven't figured out when yet, I am going to do a meetup in Chicago. Some of you will be meeting up in Chicago with me. I am going to ask that bar if they can make Caesars. I will send them the instructions on how to make a Caesar. And we're going to have some Caesars. So it's actually not bad. It's not fantastic, but it's not bad. If clams make nectar, I don't want to know about that. The nectar is basically just clam juice. So yeah. People are like, oh my God, what the hell? Caesars are good, folks, but they include clams.
I don't need to make a second closing. Thank you.
You just did that.
I did. I'm a lawyer.
Okay.
All right, so this is the part I thought was funny.
Into the chamber, and I limited my explanation of that to what he described and the like. I don't need to make a second closing. Thank you.
You just did that.
I did.
He's like, I don't need to make a second closing. And the judge is like, you kind of already did. And he's like, I did. I'm a lawyer, though. So you got to give me a break. Question, Runkle, do you want to do a meetup in Jackson Hole, Wyoming? I live 3 minutes away from a really nice gun range. I like the idea. The problem is that if I do I do meetups in places where I have a spot to be, right? Because if I do, like, I had some people who were like, would you do a meetup in LA? And I was like, yes, absolutely. If I was in LA, because otherwise I have to fly to LA. And if I fly to LA, it costs me $2,000 to go. Airplanes from Canada are really expensive. So $2,000 to go. And then, you know, $300 for the hotel if I stay in like modest hotels. So, you know, $300 for the hotel. And at the end of the day, I don't charge anything for the meetups, right? I just have people come there, which means I don't make anything from the meetups. And when I talk to bars, usually what the bar asks me for is, we need a credit card. Because if people don't drink at least $500 worth of stuff, you have to pay the $500. So, like, I'm on the hook potentially for $2,500. So I love meeting people, but at the end of the day, it's like, do I really want to spend $2,500 just to meet people? So I gotta figure all that out, and I gotta decide, right? So, Shar Anderson says, hey, Ian, DM me. I'm in the travel world and I can get everything set up for you. You'll have to DM me on Twitter because I don't have a way to DM you from YouTube stuff. There is a service that does. So, do you have to reserve a place? Why not just do it? Because if I have, like at the Vancouver one, there were something like 25 people there. And if you just have people show up and there's 25 people, the bar gets very pissed. So, yeah, I mean, there's this service that basically like arranges a cruise or like trip, and then everyone else pays for it. And if everyone pays for it, then the creator goes for free. And I don't like that because it's really ridiculously expensive for everyone else. So I don't have a good solution for that. I don't have a good answer for how to make all this happen. But I mean, one day if I was making huge money, right? Like there are some YouTube creators who make really big money. I'm not making. The other thing is that there is a potential. There is a potential that I may end up taking a job that would have me working a limited number of days a year. Not a 5-day a week, not a 7-day a week, but a limited number of days per year. If I do that and I can get like a 3-month block, then one of the things I might do is I might go and buy like a US rail pass and go to the US and be like, we're doing meetups in the following towns. And I would just take the train to go, take the train to go, take the train to go, take the train to go. I would love to do this in Canada as well. And Canada's rail sucks. Runkle, if you come to the East Coast, I will provide you with as much snow crabbing and lobster as you wish, even a carry-out package. Oh man, that sounds amazing, East Coast Canny. Where on the East Coast? What is it? US plus rail does not compute. US has rail. It's not as good as European rail, but the US rail system does actually allow for like, you pay X much and you have a rail pass that lets you keep going. Via Rail, on the other hand, Via Rail has a thing where you can't really do that. Net42, no offense, Ian, but I'm not flying to meet you in Chicago or Vancouver when I live in Edmonton. I need to set up an Edmonton meetup. I need to. The reason why I've been reluctant to set up an Edmonton meetup is that there's a guy in Calgary who wants to kill me. Guy in Calgary wants to murder me. And so if I'm like, hey, I'm doing him, like, it's one thing to be like, I'm doing a meetup in Chicago, because I'm pretty sure that fucker ain't going to Chicago, right? But if I go like, hey, I'm doing a meetup in Edmonton, then it's like a 3-hour drive. So, that's a different scenario. And I am concerned that if I set one up in Edmonton, that dude who might want to shoot me might show up. So I don't really know. Are you serious? Oh yeah, I'm deadly serious. This is actually reported in a court decision. Like literally reported in a court decision that that there's a duty to warn notice because this guy wants to. So yeah. So yeah, you know what? Fuck it. I'm just going to do an Edmonton meetup as well. And if the guy shows up, he shows up. We'll figure it out. But yeah, we'll figure it out. Do I have a restraining order? God, no. It's just a piece of paper. It's not worth shit. I see people saying Amtrak is awful. Maybe I could do maybe I could do something like rent maybe I could rent an RV and do like a trip across Canada, the US in like a rented RV. Would that be crazy? Would that be insane to rent an RV and travel through Canada and the US and set up meetups? Would that be insane? I don't know. What was that? Okay, Mrs. Runkle is saying that would probably be insane. So, please tell my boyfriend he can't have a flame-throwing dog. No, I'm telling your boyfriend he should send me a flame-throwing dog because I would love a flame-throwing dog. I don't know. Maybe that would be a bit of a. I gotta think about it, because if I had like 6 months to like, if I end up in a position where I've got a thing, I could rent an RV and just like travel around and do meetups. That might actually be a lot of fun. So, I don't know. I got to think about it. Yeah. Anyway, I don't know if the other job will materialize. I hope it will, but I don't know if it will. So if the other job materializes and I end up with a position where I am working a limited number of days out of the year, then it opens up a lot of doors. The doggos can come in the RV. I probably wouldn't bring the doggos. The doggos would probably stay with Mrs. Runkle. So you would miss Mrs. Runkle. You're not wrong. You are so not wrong. Why drive across country in a house when you can stay at a car and use hotels? Because the hotels cost like $300 a night. Unless I stay at really sketch-ass hotels, which I've done. Have I told you about some of the worst hotels I've ever stayed at? Let me tell you about some of the worst hotels I've ever stayed at. So, I stayed at a res hotel, and if you don't know what a res hotel is, it's a hotel that's on a reserve. And some res hotels are really nice. I have stayed at res hotels that were basically like white glove service. This one was the other kind. So I was staying at this hotel, and you go in, you pay, and they hand you your key, and I go in. Now, I am concerned as I'm staying at this res hotel because it has a look. And so the first thing I'm doing with this hotel, it's not the one where the dog joined me, because the dog was at a client's house. The hotel was an actual hotel. Well, motel, but same. And so I stopped, and the first thing I'm concerned about is that there might be bed bugs. So I'm doing a check for bed bugs, right? Where I'm looking behind the bed, seeing if there's bed bug sign, looking in the drawers, all of this. And I pull back the blanket. And I pull back the sheet. And there's the undersheet, the lower sheet, right? And I see under the undersheet, there's a big brown stain in approximately human shape. And it's that like red, brown, rusty kind of color. And I'm like, somebody died in this bed. So I call up and I'm like, hey, can I get another room because somebody literally died in this bed? And they're like, yeah, that happened, but we don't have any other rooms. So tough shit. And I'm like, oh, okay. So I slept on the floor. I'm just going to address this. It was not a period stain. It was absolutely not. It was shaped like the entire person, like the entire head to toe. Like And the stain was enough, it was big enough that if it, like, it, there is no way to leak that much blood and still be alive. It was very clearly somebody died in that mattress and they just put a sheet over it and were like, cool. And I was like, so I slept on the floor. Don't usually understand res. Res is short for reserve, or reservation. And basically, how do I put this? Canada set aside a whole bunch of land in different places, usually shit land that nobody else wanted, but they set aside a whole bunch of land for Indigenous Canadians. Usually it was the shittiest land in the middle of fucking nowhere because Canada was being assholes to, to the Indigenous. And previously they were not allowed to leave the reserve without a pass from an Indigenous agent. Like they actually needed a pass to leave. That's not the case anymore. So, reserves, depending on their local resources and how they're managed, can be anything from really nice places. There's some reserves that are really nice to really kind of third worldy. And it really depends because you've got reserves who are out in the middle of nowhere and, don't have any resources and, they just, obviously they have no money. So what do you mean they weren't allowed to leave? Like prisoners? Yeah, they weren't allowed to leave. Like, you were not allowed to leave, and if you were found off reserve without a pass from the Indian agent, you could be arrested. That was absolutely a thing in Canada, like 100%. One thing I keep advocating for is I want Alberta to specifically issue a pardon or like to take down a monument to a guy named Sunchild, because the monument isn't flattering. It basically accuses him of murder when he was acquitted of the murder. So yeah, here's the thing. I like, different reserves have different cultures, and a lot of Indigenous cultures have a lot of really cool culture. I'm an outsider on reserves, but I've quite enjoyed, the interactions I've had with people there and so forth. But a lot of them are kind of fucked up. So be aware of that, right? I did do a video on this, on the Sunchild thing, because I want that monument gone if I can. So yeah, let's get back to it. I'm wandering.
Okay, I respect that on both sides. All right, so at this
Yeah, it's against the law, but they didn't give a shit. So yeah.
point, why don't we, I said that I was going to step off for the gathering of the evidence. Let me not do that. I'd like the council to just make sure that all the evidence, the exhibits are in order. You'll note your contentment on both sides. If you folks can take a look at the verdict form as well. I don't know if you already have. It's not.
So everybody agrees that the verdict form is fine. And then it goes to verdict watch for a good long time. And then it comes back and yeah. So here we have the judge again. Here we go.
In a civil case, there is no requirement that a judge explain their reasons for reaching a verdict after a criminal bench trial. I do so in this case because I think that Ms. Fitzsimmons, Officer Noonan, and all the people involved in the tragic events.
Oh, I have stayed in some absolute shit hotels. I have stayed in some absolute bad hotels. So yeah, it's a thing.
June 30, 2025 deserve an explanation. Next, I'd like to take.
So I just want to go on a little side rant here. The judges like to do this thing where they keep you on tenterhooks as to what the verdict is going to be. And I have already decided that if I am ever a judge, and I'm unlikely to be a judge ever, but if I'm ever a judge, the way I will deliver verdicts is like this. In the matter of Kelsey Fitzsimmons, I find that she is to be acquitted on all charges. And now I will explain my reasoning. Because I hate the, I will never tell you where I'm going until the last possible fucking second. Just tell us. It's okay. Tell us if you're acquitting or convicting.
The opportunity to publicly thank and commend the attorneys in this case. They all did an exceptional job presenting the evidence and conducting themselves in an extremely professional and civil manner.
By the way, one thing that is the kiss of death on a verdict. So here you see the judges saying all attorneys did a great job. Everybody did an excellent, thing. And I'm like, okay, that doesn't tell us much. The kiss of death on a verdict is that when they're like, now I would like to commend defense counsel for their excellent work on this hearing. And I'm like, fuck. They'll be like, defense counsel argued this case excellently and with skill and ethics and whatever. And my client is like, oh, that's good, right? And I'm like, no, that is not good. If the judge is telling me that I did a great job, it's because he's trying to soften the blow of you're getting convicted, dude.
They did so under the public spotlight in an emotionally charged case. I commend you. To the extent that any of the prosecutors and attorneys may be vilified or subjected to public scorn for simply doing their jobs, in this case, I say that any such scorn is unfair, unwarranted, and simply wrong.
And I say, tough shit. We're allowed to have opinions, Judge. And I don't think that the prosecutor should have been fiddle fucking the gun all through the close. Somebody said, what does it mean to be fiddle fucking? Well, you know what fiddling is, right? You know what it is to fiddle with a gun. Well, fiddle fucking is fiddling with negative emphasis, right? I see some people noticing that the bailiffs are right behind Kelsey Fitzsimmons. That's very common. The bailiffs don't get told what the verdict is ahead of time, so they are in position to bring her into custody if needed or tackle her if needed. If she gets up and makes for the door, they're ready.
These prosecutors and attorneys fought hard, but performed their solemn jobs fairly with the utmost civility,
it's actually pretty good.
Civility, and professionalism. They served as a shining example of our adversarial system in operation. Now, I'd like to publicly acknowledge the crucial and often thankless role that police officers perform.
Can says shake hard. Oh, come on. The thankless off, come on. Judge. The thankless job that police officers perform? Really? Everybody thanks them every fucking time they show up.
Role that Ms. Fitzsimmons herself, like Officer Noonan, willingly and selflessly performed for the citizens of North Andover.
You'll notice here that at this point for the verdict, they have more cops in the back row. They also have this guy. Nobody's heard of this guy. Oh, that's Mark Betterow. Betterow is... I take no shame in saying that Betterow is a smarter lawyer than I am. And the reason why I take no shame in that is because Betterow is super fucking smart. And so being like, I am dumber than Betterow still leaves me a lot of room to still be pretty smart. Yeah, he's, it's good to see him there. And I have huge respect for Betterow. He's one of those people I just like unabashedly fanboy. So yeah.
For this, you should be thanked, not disparaged. For those that think that serving as a police officer is easy, or that officers don't care or take pride in their work, I say with more than 3 decades of experience in the criminal justice system that you are naive, misinformed, and sadly mistaken. The work of police officers is especially fraught with peril today because of our exceedingly cynical, polarized atmosphere where our citizenry often believes that there is a conspiracy under or around every corner.
Yeah, and unfortunately, we're often proved right. And that's the issue, is that, like, people come out with wild conspiracy theories, and then the wild conspiracy theories are just like, oh, right, that actually just makes perfect fucking sense. Karen Reed trial was like this wild conspiracy theory that I was waiting the entire trial for, like, this conspiracy theory is going to be fucking stupid. This conspiracy theory is going to be broken. This conspiracy theory is going to be ridiculous. The defense is going to fall on their face. They're going to get embarrassed. They're going to get crushed by this, conspiracy theory that they built. And then we went the entire trial and I was like, the conspiracy theory makes the most sense in this case, right? Nothing else actually makes sense in this case. So, like, if we want to stop the conspiracy theories, they've got to stop being proven right. Like, that's the thing. If you want, you got to start proving them wrong.
I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants like Officer Noonan and his fellow officers doing the best they could under tragic, rapidly evolving emotional circumstances. What I also saw was a young woman, Ms. Fitzsimmons, who was also a dedicated public servant, react to sudden, confusing, and heartbreaking news. Now let me turn to the evidence and the law. Our system of justice requires me to decide this case solely on the law and the evidence. So the only things I have considered in reaching my verdict are the 98 exhibits admitted during the trial and the testimony of the 11 witnesses that testified here in open court. While it may be cold and uncaring, our system of justice demands that emotion, sympathy, and concern for the consequences of my decision play no role in my decision. As for the...
I mean, he's right. You can't decide the case based on, I like this person versus I don't. So, it's important.
Law, in order to prove Ms. Fitzsimmons guilty of the crime of assault by means of a dangerous weapon, the Commonwealth must prove the following 3 things. We lawyers call these things elements beyond a reasonable doubt.
So let's talk about elements of the offense. As lawyers, one of the things that you have to do is you have to break down a charge into different pieces. And the reason why you have to do that is because you can imagine the charge against your client as something like a you can imagine as something like a clock, right? And as a defense lawyer, my job is basically to see the clock the prosecution is trying to build and keep it from working, right? So I need to fuck up like a single gear. And so I need to know where all the gears are, right? But from the prosecution side, they have to build the entire clock. So they need to know what all the gears are so that they can make it work. But you have to be able to sort of atomize the charge and break it down into different pieces. So for the assault with a dangerous weapon, you know, there's intent, there's all of these things, and you have to break it all down.
First, that Ms. Simmons committed an assault on Officer Noonan. Second, that Ms. Simmons intended to commit the assault. And third, that the assault was committed by means of a dangerous weapon. The sole issue before me is whether the Commonwealth proved each of these three elements beyond a reasonable doubt. And more specifically, under the circumstances of this case, the narrow issue before me is whether the Commonwealth proved beyond a reasonable doubt that Ms. Fitzsimmons pointed a firearm at Officer Noonan for any perceptible amount of time. What is not before me are the legality of the issuance of the restraining order to Mr. Alayan, the reasonableness of the procedure used by the police to serve the restraining order, the legality of Officer Noonan's use of force, and issues regarding the custody of Caden. It is not my place to decide these issues or even mention my thoughts on them. I am thankful for this because my role has been hard enough. What has made my job especially difficult in this case is that by and large, I found the testimony of Officer Noonan and Ms. Fitzsimmons to be credible on the material and relevant points.
So at this point, this is the point where I was like, he's got to be acquitting. Because when he says, I found the evidence of Officer Noonan and Kelsey Fitzsimmons to be credible, I'm like, that has to be an acquittal. Because as soon as Kelsey Fitzsimmons is credible, you can't convict her. That's reasonable doubt.
In my experience, this is unusual and somewhat perplexing. On the one hand, Ms. Fitzsimmons credibly testified that she never pointed a firearm at Officer Noonan. On the other hand, Officer Noonan testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agree that it happened in seconds near a narrow doorway, and the crime scene photos show that the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Noonan's left. The door frame was also made, strike that, the door frame was made still narrower when Officer Noonan used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever racking the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those.
So this is the problem, is that ultimately the prosecution kind of shit the bed. And if I was the prosecutor, if I was on team prosecution on this, and I'm not, if I was on team prosecution, I could have assisted them to better marshal their evidence to try to secure a conviction. On the other hand, if I was on team defense, I could have assisted them to better marshal their evidence for the defense. There were a bunch of gaps on the evidentiary record, and I was just like, So I recently did some consulting for a lawyer. The lawyer was like, I have some gun issues on my case. Can you help me? And at the end of it, I told the lawyer, I was like, I don't know what I should be paid. I am doing this consulting on a pay what you want basis. Pay me what you think is fair. And the lawyer's like, I think at least $500 an hour. So that's what I billed him. And the thing is that I know guns better than most lawyers. And I don't mean to be an asshole. There's no way to say that without sounding like an asshole. So we're just going to lean into it. But a lot of lawyers do not know the difference between an SKS and a BMW. And this creates a real problem for those lawyers when they try to argue things and they just don't know. So you get lawyers who come to me and they're like, I don't know what's happening in this case. And I'm like, okay. And I can help them break things down and to understand how the gun shit works. So, for example, there was a case where there was a particular gun and they only conducted certain tests on it, but they didn't conduct other tests. And I was like, here's what this means, and here's how you attack it, and here's what you need, and here's, you need an expert for this, unless you're going to try to get it out of their expert, but, it's just a fucking crapshoot if you're going to do that. So the prosecution got things wrong here. They missed steps. The defense got things wrong on the guns. They missed steps. On balance, that helps the defense. So, yeah.
Circumstances. However, even if I assume that Ms. Fitzsimmons lied about not racking the slide, it does not detract from the adamancy and credibility of her testimony that she never pointed the gun at Officer Noonan, about which he was equally as adamant that she did. Perhaps the Commonwealth could have easily met its burden if the officers had been wearing body cameras. But under these circumstances, I am left with a reasonable doubt, and I am duty-bound to find that the Commonwealth has not met its burden to prove that Ms. Fitzsimmons committed an assault by means of a dangerous weapon on Officer Noonan, and my verdict is and must be not guilty. With that, I will hand the signed verdict slip. Did I lose it? I will hand the signed verdict slip to Mr. Ruane and ask that he advise Ms. Fitzsimmons of her statutory rights.
Can I just say how fucking difficult this moment can be? Because you want to be like, okay, we are, but you don't want your client to go, yeah! I had a client who went, yeah, fuck you, motherfucker. Like, literally said.
That he to Mr.
Oh, yeah, there's Mazza right there. The client literally went, yeah, fuck you, motherfucker, and to the crown. And I was like, sir, sit down. Yes, that was on acquittal. And the judge just was like, I trust there will be no further outbursts. And I'm like, Judge, I'm on this. Shut the fuck up. Shut the fuck up. But yeah, my client was not gracious in victory. We'll put it that way. But so what I want from my client when the verdict is read is to like calmly nod, maybe shake my hand, maybe give me a hug if they need to, but not to have some massive outburst, right? No, they didn't get held in contempt. The judge understood, but it was still like, no, please don't.
Wayne, and asked that he advise Ms. Fitzsimmons of her statutory rights.
Ms. Fitzsimmons, could you
I love the handshake. The handshake is classy, right? The handshake is good.
please stand? On docket 2025, 77 CR 311, count 001. The court having returned a verdict of not guilty, the court orders that you be discharged of this indictment, and this indictment only, and go thereof without delay. Kelsey Fitzsimmons, as required by statute, I must inform you that the records regarding the charges for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you may use the request not to seal form posted on the trial court's webpage on mass.gov, or a copy of which I will hand to your counsel. I cannot accept the form here in court.
There's a lot of cops making sad face right now. It's like, Muffin, you don't get to send your fellow officer to jail. Sucks to be you.
You must submit it to the Commissioner of Probation at the address provided on the form. Do you understand?
Yes, I do.
Thank you.
Thank you. Court is in recess.
Good, all right. Please exit quietly, and thank you once again.
There you have it. A not guilty.
Love this. I love, watch this, the handshake.
Quietly, and thank you once again.
There you have it. A not guilty.
Yes. Love Bettero's little, we're going to watch that again. I can't get enough of this. Bettero's face there.
Please exit quietly, and thank you once again.
There you have it. A not guilty.
I love his like, fuck yeah face. Bettero right here is like, he's like, I came to, I came to play.
Decision by the judge in the Kelsey Fitzsimmons trial. You see Kelsey right there with her lawyer right there giving him a hug. She is now free to go. The records will be sealed, and she moves on to the next phase of her life. The key here, Glenn, I thought, was that the judge said both sides were credible. He believed both sides, and that possibly this all could have been solved with body cameras. He threw that in at the end. Body cameras would have avoided.
So the thing is that I predicted this. I said, oh, look, the judge is most likely to say that he found everybody credible, and that because everybody's credible, he cannot possibly convict. I said that yesterday, and it remains true, right? I said that was what was the likely result. She is now free of all of the like bail conditions, and she gets an interview right after.
As we begin with her attorney, Mr. Brito.
It's just another day at the office today. Just want to say that we want to thank so many people. We want to thank Kelsey and her family for having faith in us. We, meaning Martha and I, want to thank so many people that Kelsey and her family had faith in us. And, we had a very tough playing field for a long time. And we also want to thank Judge Karp, who did a great job and was a gentleman and treated us fairly and with justice. And that's all we ever asked for. And we finally got it. So we're relieved. And, but other than thanking everybody, I just want to hand it over to Martha.
I think this is the classy thing. This is so classy. Watch this.
And, but other than thanking everybody, I just want to hand it over to Martha, and she's going to have some words for everybody first.
Yeah. So thanks, Tim.
You know how many dude lawyers I've seen who talk over their female coworkers? And he's like, I want to hand it over to Martha. She needs some screen time. Fuck yes, Bradle. Good work. You remember, I'm forgetting the trial now. What's that? I know the trial, but I'm forgetting the name, where you've got the prosecutor who was there, who got the conviction, and then the DA is like, let me talk over her. Banfield, yes. And the DA like wouldn't fucking let her talk. And is like, I've got the big dick here. And it's like, yeah, you are the big dick. It's right coming out of your fucking neck. I thought this was super classy. So, yeah.
This is not only the right result, it's a righteous result today. It's been a long odyssey for those of you who followed this. And we started off in this case, understanding, as we all do, and as the judge said, policing is a tough job. Being a mom is a tough job. And on June 30th, Kelsey had to do both. She's trying to be a mom. She's trying to get back to work. And then her world fell apart. And unfortunately, on that day, as she said to the judge, and you heard in court, she had to deal with all that. And unfortunately, what happened in that bedroom started a chain of events with a narrative that they never diverged from. They never asked her about it. They rushed to judgment. And that case took on a life of its own, which unfortunately interfered with her life for an unnecessary and difficult time. I think Tim and I have known from the beginning that that wasn't fair, that the charges probably weren't fair, and that we were going to deal with the system and we were going to take this to trial. And as Kelsey has said, without fail, she just wanted the truth to come out. She was able to do that when she testified in this case. And again, we're grateful for the judge's work. We're happy with this decision. And it's the right decision, as we said. She was always innocent until proven guilty. The Commonwealth did not meet their burden of proof, and she is innocent today.
Kelsey, what was it like to hear that word, not guilty? To hear the judge say not guilty this afternoon? You sat there, you were on the stand yesterday telling your story. Share with us what that was like.
So, I got shot.
You don't say.
To jail for 103 days. I haven't seen my son. I had to sell my home that I worked very hard for. So this is my first breath of fresh air, and I feel like I can breathe again. However, my fight is not over. I have a son that I need to reunite with, and that's where we are right now.
I feel so bad for all of the shit she's been put through. Like, life just suddenly became all uphill for her, right? Everything was going great. And then suddenly, and ladies, men, this applies to both of you. The worst mistake you can make is getting in a relationship with a bad person. I am super fucking lucky. Mrs. Runkle is amazing. Mrs. Runkle is insanely wonderful. But so many people's lives get blown up because of bad relationships. And yeah.
Can you talk about Eden, what's next for you, and how this verdict might help you reconnect with them?
I won't get into that, but I will say I am really excited to see my son again.
Do you have any plans to hire a personal injury attorney or have a personal injury?
Now, God, this pissed me off so much because you've got all of these reporters and they're like, can I ask you questions about your next legal case? And it's like, why the fuck would she answer questions about her next legal case? That's the dumbest thing she could answer about.
I will also not get into that, but
yeah, today we're celebrating this verdict.
Yeah,
and that's
I'm
what we're
focusing on today.
One day at a time.
And I also would just like to thank everybody who stood outside each and every day, supported me, believed me before I got to tell my story, because it wasn't 9 months later until I got to tell the truth. And that was a long 9 months. And through those 9 months, you guys knew the truth. You guys believed in me, and thank you for that.
Kelsey, what's the message? Kelsey, what's the message to others?
I don't know if she's speaking to like people in LawTube, but I feel like she's speaking to people in LawTube. So, yeah.
That are in a position like yours after what happened today with the not guilty verdict, what would you tell other people?
Don't stop fighting for what's right. And when you know you didn't do something wrong, keep fighting for that.
Kelsey, do you want to be a police officer again?
I won't comment on that either. I don't know what my...
If she wants to be a police officer, she can't do it in North Andover. And quite frankly, if I was her and I wanted to be a police officer, it would have to be outside of Massachusetts, right? Somewhere outside of Massachusetts. But I mean, I feel like she can do better. Hell, Kelsey, start a YouTube channel. If you want to start a YouTube channel, I will help. And like, come on the channel. We'll do a big announcement video. We'll be like, all right, here's the channel you got to go subscribe to. Fucking do it. She did partially law school. Do that. Like she did part of law school. If she needs an LSAT score, I will happily offer her, like, Kelsey, I used to tutor the LSAT. If you need LSAT help, I will help. Like, whatever you want to do, I want the world to be open to her. And yeah.
career goals are at the moment.
What have the last 9 months been like for you as a person, as a mother, as a defendant?
There's not a word. If you want an image of it, picture me on a mat in a jail cell crying for my son day after day after day after day.
Now let's talk about her in a jail. She's a police officer, right? And the thing is, you might say, oh, well, she's not a police officer. The cops are against her. It's still that she's a police officer. You know, it's still that she's a police officer while she's, you know, for the purposes of being in jail, she's a police officer, right? So they're going to treat her really, really badly, right? Really badly.
That's there's not a word for that, but that is what happened to me.
Kelsey, do you feel like you're owed something now, considering that you've been found not guilty of all of your stuff?
Buckets of fucking money.
What's happened to you?
I'm going to leave that one to you.
Leave that one to the lawyers, sir.
Hey, Kelsey, the judge was not exactly speedy in getting to the ultimate decision. How painful was that to sit there?
The judge wasn't speedy? Are you fucking kidding me? The judge came back with a verdict the same day. Judge wasn't... They need to stop with the reporters. Like, why is it that they have these media people who ask these questions who are so fucking dumb about legal shit? I have been waiting for a decision from the Court of Appeal for like 4 fucking weeks now. This guy turns around a verdict same day with a written decision, and you're like, he took a long time, didn't he? No, he didn't. Christ. He took like 5 hours. This would be a long time if he was passing a kidney stone or taking a shit, but he's issuing a judgment. It's a really short time.
I mean, it's okay. he had to go through all the evidence, and there was a lot. So
We thought he was pretty quick, actually.
yeah.
Yes.
And we obviously, with a good judge, didn't have the issue with the jury. He told us when he was going to decide. We knew he was going to write his decision, which was helpful, and he told that in public. So we had this hybrid trial with the judge who was both the judge and the jury, and he was forthcoming throughout the trial, transparent, and told us he was going to tell us why.
Seriously? Oh man. Oh, okay. I'm gonna stymie the rest of my thing. He was talking about the speech he gave when he gave his decision. I mean, they give speeches. That's what judges do. I received a verdict at one point, and the judge reading the decision took 3 hours. So, yeah.
The decision, which of course we would not have gotten with a jury verdict. So it's helpful to have that.
Martha, you talked about how this is a just verdict, in your opinion. Were you surprised these charges were brought in the first place, and why do you think they were?
So I'm just going to repeat what I said earlier to that question. A set of things got set into a
I thought he meant the delay while the judge was deliberating. The speech wasn't that long. I just think that judges should front load the decision, not end load it.
motion on June 30th that then followed a narrative starting that night in that room that never really got challenged, that never really got investigated with any investigation of her, that never got tested in any way. But the presumption was that she was a defendant in this case. And so that's unfortunate because she couldn't talk for a while. She's being held for a while. She never got a chance really to tell her story. Ordinarily, the system shouldn't work that way, but both Attorney Bradel and I have been on both sides of the system. We know how it works, and sometimes when it doesn't work well and it works slowly, that's unfortunately what happened in this case.
I mean, I don't disagree with this. This case was a loser from the get-go. The prosecutor should have looked at this case and been like, yeah, you were complaining about taking ages to get to the verdict. I was complaining about the judge reading out, like, that the judge doesn't say what, but I took that question, assuming I'm correct in my interpretation of the question, to be like, why did it take 5 hours to deliberate? 5 hours to deliberate is nothing, right? I was expecting we'd get a decision back in like 3 weeks, not the same day, right? I absolutely thought we'd get a decision in like 3 weeks. If he's talking about the speech, it wasn't that long. I just think that the verdict, like that you should read the acquittal versus not first. So I don't know. Maybe I misinterpreted the question.
And we fought every way with Kelsey to make sure that justice was done. It took longer than it should have, we think. It was more painful than it should have been. But look, we got the right result today, and we are happy with that.
Kelsey, what's the next thing you
starting
want to do now that
today,
you're not
all of
guilty?
your-
Guys, hold on. Let's give these guys over here a
Starting
chance.
today, all of your bail restrictions are lifted, and you said you can breathe again, but there's a lot of changes that are going to take place today. You have a lot more freedom than you had. How do you plan to start that journey of freedom?
I want to go for a walk with my dog.
Oh my God. When I heard that, like earlier today, I actually paused this and I went and hugged my dogs because, oh my God, they're such cuties. There's like, just, oh my God.
I can't wait to take him for a run. I haven't been able to do that. That's our thing, is going for a run. So.
And don't forget, she couldn't do that.
Right.
She had to sit in her house. That was her best case scenario, that she was a prisoner in her own home. And then her worst case scenario at the outset of this case, and like Martha said, this was such a bumpy road, a long, bumpy road that never should have happened. And, you know, she had to spend time in prison. As a former police officer and corrections officer, she gets sent to jail. Someone with no criminal record, someone who shows up to court, has a wonderful history in this county, and sent to jail. To me, it's unprecedented. It was
absolutely insane. The judge that like sua sponte revoked her release That needs to have a whole fucking investigation. That needs to be insane. Oh, Julie, I'm so sorry. I lost my fur baby. My cat died early yesterday morning. Hug your pets. I am so sorry.
Terrorized her, and it's a horrendous, awful thing that happened. This case started out as a circus, and we are so grateful to end up in Lawrence in front of Judge Karp, who, like I said, is an absolute gentleman, a consummate jurist, and he treated everyone in that room with respect, with humanity, with kindness, and we were very appreciative for it.
Do you have a message to your former colleague?
No.
What do you make of the
I have a message to her former colleagues. And the message is, see if you can get it all the way in, fuckos.
Judge saying he credited both Kelsey's testimony and the testimony of Officer Noonan. He called it confusing.
Well, Charlie, you know, he's the fact finder. He's got to make the sausage in the back room. You know, he's got to think about everything, and you know, it's a tough job for any fact finder in any case, really. But I mean, you know, Kelsey has said to you guys every time we're out here, I can't wait to get to the truth. I can't wait for the truth to come out. And finally, she got her chance, and she told the truth, and she put herself out there. The one person in the whole room that didn't have to testify. She's the one that got up there, put herself out there, and told the truth. And the judge, I think, treated her wonderfully and was very humane and kind and listened attentively to not only her, but to everybody in the case. And we're grateful for that.
And I'll just add two things to that. First of all, people can believe they're telling the truth when they're mistaken, so they can appear to be credible but be wrong. And when a defendant like this is credible, I think, as Tim said in his opening and his closing, that creates reasonable doubt. And so that's
when the accused says, I didn't do it, and is credible, that is reasonable doubt inherently. That's the end of the story.
Standard. The Commonwealth always has the burden beyond a reasonable doubt. We didn't know the one thing we weren't going to get was a hung jury here. So,
Josie, do you have a question? You okay?
Not sure you but it's okay. How are you feeling, Kelsey? I feel good. I feel relieved. I was eager to do this, and I said from day one, the truth will come out, and it did.
Anybody else?
Maybe if this is doubling up, but you testified that 2 weeks isn't enough for any mom. The judge seems, and even the prosecutor seems to connect with that. 9 months.
There's not a word. There's not a word. It's the most devastating thing that you can do to a new mom. And hopefully changes will be made where a new mom or anyone will never have to go through something like this.
We've talked about that, and we're going to talk about that with legislators. What kind of a system is it that somebody can walk into court, fill out a piece of paper, and in 15 minutes, take someone's baby away, take a mom of a newborn's baby away? It's just an incredible thing, and it shouldn't happen. And we're going to work on some reforms of that statute.
Tim, how much impact do you think it had that
Now that is interesting. They're like, we're going to fight to change the law. That's interesting.
the complainant had connections, friends within the law enforcement community? So maybe you can't be just anybody coming and filling out a form.
To be determined, Michael. You know, to be determined. We have some other investigations to work on, and we're going to leave no stone unturned, and we're going to find out exactly how and why this happened, who's responsible, and you know, we're not stopping here.
Hey, fuck her with the sign. She's already free. Get the fuck out.
You know, the things that happened to Kelsey, we have. With respect to her home being broken into, we've reported that to the FBI. And I've had it with Essex County, and there are other avenues to pursue, and we're pursuing them. And we're in touch with the FBI on all sorts of federal crimes that were committed, and we're in the process of dealing with it there. That's one example of other avenues that we're taking here. You know, we're not sitting here at Essex County's beck and call.
Oh, seriously? That's Scott McGinnis? I haven't seen the person's face. So it's just like the sign is distracting me.
We know where to go and we know who to talk to, and we are doing that. Anybody else?
Oh, great.
Hello, sign holder.
Thank you, everybody.
Thanks, everybody.
Thank you. Thank you so much.
Listening to Kelsey Fitzsimmons and her legal team. As you can see, she is outside.
Okay, I like the flag. Sorry, the sign was distracting. People are sorry, Scott. I didn't mean to be a jerk. My bad. I'm glad you're there for support. I just it was distracting me because I've got attention deficit. So it is the thing.
Essex Superior Court in Lawrence, reacting to the fact that she has been found not guilty of assault with a dangerous weapon for an incident on June 30th of 2025 when she was being served a restraining order.
That is amazing. Scott has been out there. Oh, really? With the sign and flag for every hearing. Okay, I take it all back. Rock that sign. So, yeah. He's always been on the ground. Fair enough. Then I am the one on the wrong thing there. First you diss another law tuber, then Scott catches strays. We were doing victory laps out there. I mean, this is one to do victory laps on. So yeah, awesome. There's still time to delete this stream. I'm not. I will own my shit. It's I mean, this is a really great result. What I want to see happen from here is I want to see the judge who ordered her held. I want to see an investigation as to how that judge ended up on that case, because it seems that she just decided she was going to be on it. And they mooted the recusal thing, but they shouldn't have. That should have been heard. What is it? Anyone else you have beef with? I mean, at this point, all I need to do is pick a fight with like Winnie the Pooh and the Care Bears. It sounds like so. I'm like, yeah, I seem to be aiming in the wrong directions here. This is a great result, and you know, I am so happy to see it. I am cracking off another thing there. I just this is pretty awesome. I was worried. I came into this thinking she's got about at the end of the prosecution's close, I was like, she's at about 80%. 80% chance she wins. And that had me nervous. Laura, chill out. Chill out. We're just being fun here. And Dude with Sign is in the chat. Dude with Sign is not upset. So, like, you're at an 8. Take it down to a 2. I have acknowledged that Dude with Sign he's doing good. We're good. So, I mean, when I'm like at 80%, I was like, I really hope this doesn't bounce the wrong way, right? And I was really glad to see the verdict. And when the verdict came in and it was like, you know, basically exactly as I called it, I was like, well, I couldn't ask for something better. I was especially nervous when the judge went in and was like, police officers are the greatest humans that ever lived, and we totally, like, police officers do nothing wrong, and I love cops, and cops. And I was like, oh shit, is he about to do a dumb thing? Is this judge about to curb stomp her for, like, daring to criticize police. And no, he was just doing the thing where it's like, okay, you know, yeah. What is it? Whoop. Don't go insulting Microdots because the new video just dropped for Patreon members, public in 24 to 28 hours. It's outstanding. 1 hour, 22 minutes. I don't know why I would insult him because usually his videos are pretty solid. He actually does some great, work. So I am very relieved. Any progress on going over Maya's court filing last week is about Greg Anderson being inappropriate with her. Oh, I don't have a copy of it yet. I'm trying to get a copy of it. I'm just going to note I am buried in shit I want to cover. There is so much shit that I want to cover right now, and I am so buried in it. As an example, today I bookmarked like 4 things that I want to go over. And like one of the things I want to go over is Smith & Wesson getting sued by nuns. Nuns sued Smith & Wesson. I want to go over a lawyer who appeared in court with no pants. Because like a lawyer totally Winnie the Pooh'd it in court. And I'm like, I need to know more about that. So I'm thinking like Monday, we're going to have a lot of shit to go over with like Winnie the Pooh and, all of this. Yeah, I have a whole bunch of stuff that I want to cover. And yeah, it's hard to sort of get it all done. It's hard to all of that. But there's so many things. I want to track down the Maya thing. I also am trying to do this. So hopefully there'll be a Lawyer You Know collab very shortly. And I mean, ages ago, I told Lawyer You Know, when Lawyer You Know was at like 20,000 subs, I told Lawyer You Know, you're going to be a way bigger channel than I am. And he was like, oh, come on. Anyway, he's a way bigger channel than I am now because he does great stuff. And yeah. So Lawyer You Know, I'm hoping to do a discussion with him about sort of the gun stuff aspect of the trial because there's a whole bunch of aspects there. But yeah, I mean, I got a whole bunch of stuff. We're going to do all of that. Jaded for Justice, can you point me to the Sunchild video? I will have to try to find it. And I'm only like 75% certain that I did a video on it. So I need to track it down because, so the Sunchild thing is basically, it's a historical allegation against this indigenous guy, and they charged him with murder. They said he killed a police officer, and he was acquitted. Sunchild was acquitted of murder of a police officer in a time that was super fucking racist. Super racist. And so, like, but they actually put up a monument to him in the middle of nowhere in Alberta. It's just like sitting. Me and Mrs. Runkle found it because literally we were like, we're driving around in southern Alberta and we were like, okay, can I say what the issue was? I was like, I need to pee. I need to find a place to pee. And so I pulled over and I was like, all right, I'm going to pee. And then it's like, all right, there's this monument here that's overgrown. And the monument was accusing this Sunchild guy of murdering a police officer, notwithstanding that he was acquitted. And I was like, Why do we still have a monument that accuses this guy of murdering a police officer when he was cleared of the murders? Like, so that pisses me off. If it was legal to do so, I would go, no, I didn't pee on the monument. I peed just in the bushes. Why do people want to know about where I peed? Okay, moving on. But I wish I could just go out and just like smash the shit out of that monument with a sledgehammer, because it shouldn't exist. It's like one of these things that should not exist. Was Sunchild, he was indigenous, right? So it was a thing, right? So I just the monument pisses me off because it basically implies that Sunchild committed the murder, notwithstanding that he was acquitted. And I'm like, no, don't. So yeah. All right, let's cover some super chats because I am way freaking behind. So scrolling back to up to the top, Mega's autistic, really enjoying the daily Runkle streams. I will probably do my next stream on Monday, which means I will probably take a break, get some sleep tomorrow. I am tired. I am just fucking tired. Today is has been a chaotic day. Real KX2, drink. I love it. Not sure how I feel about tearing down monuments. Deleting history kind of dooms us to repeat our worst acts. I mean, I wouldn't mind them keeping the original monument stone there if they put up another one just being like, Sunchild was cleared of the accusations and, you know, the actual murderer is unknown, right? Like something like that. Yeah. This case took a lot out of Runkle. What took a lot out of Runkle this week? I woke up and I couldn't get sleep because my back has been really, really killing me, right? It's been just absolutely. And so I haven't been sleeping all that well. Normally I try to get a nap in between, like, I haven't been able to nap very well, so I haven't been able to get much sleep. Work has been kind of crazy, and so I mean, I've been, you know, grinding things out at work, and then I do the streams in the evening, right? So it's just I'm really tired. I'm just really, really tired. And, you know, I'm not blaming anybody. It's just me. It's, but I'm tired. I need like I need a couple of days. Did you get injured? Scoliosis, life. So I have scoliosis and I also have, I don't know if you guys will be able to see it. I'm going to try to show you. So when I do this and like, if I put a flat surface from the points of my ribs, it should be flat, right? If I put a flat surface at the 2 points of my ribs, right? It should be flat and parallel and like, you know, parallel with me. The problem is that it's actually at a diagonal. And the reason why it's at a diagonal is that my dad was a fat ass. I think that's the medical term. But also he has a bad ankles run in my family. And so he rolled his ankle and he fell on me. And my ribs, when you're a little tiny kid, your bones are flexible. And so my bones went and skewed over to the side. So my ribs are not the right shape. And so when I went to the doctor, like I moved from BC to Alberta, and when I came to Alberta, I went to a new doctor, and the new doctor was like, I want to get you some x-rays. I want to see what's going on because your chart says your back is bad. So he went and got like x-rays for me. And the x-rays, my doctor came back and he's like, do you want an AISH note? So AISH is disability, right? AISH is like, I can't work and I need disability. And I was like, no, I don't want an AISH note. I work, I live my life. And he's like, okay, because normally when I see like a back like this, I am writing a note saying you can't work and you're going to just, sit at home and collect a, collect a disability check. And the thing is so I could get the disability check, right? My back is fucked enough that I could do that. But I don't want to do that. I want to go hiking. I want to go camping. I want to go, do 3-gun matches. I want to go meet people in different places. I want to argue cases at the Supreme Court. I want to argue cases at regular court. I want to all of these things. And so if I sit at home and I'm like, my back hurts and it really fucking hurts. Like there are days it hurts so bad. There are days it hurts badly enough that I have to throw up. Like when you have enough pain, it makes you nauseous. So my back has been hurting more lately and it's rough, right? That plus not being able, like I can't sleep because I'm in pain. I'm, doing streams, I'm doing law. I'm burning at both ends of the candle here. And so I need a couple of days. I'm going to take a couple of days. I'm going to try to, recover, revive, and then back to it. Right. So it's just, that's the way things are. It's the way life is sometimes. And I don't know if, at the end of the day, like, I don't know if I would be the same person if I didn't have these things, because if I want to do the pro bono thing. I want to fight for people for no money. And I'm not sure that's who I'd be if I wasn't the kind of person who gets up in pain. So I really I don't know. It's kind of a weird thought, but yeah, I just, I keep going. I fight for, where I can, but some days it's just really fucking hard. And, so you always have to, my dad, when he was, I think it was 5-10 years ago, my dad blew out his ankle, or not his ankle, he blew out his knee while he was hiking down a mountain. And he walked out on a blown out knee. And the surgeon that he spoke to was like, how the fuck did you walk down a mountain on this? And he said, well, the thing is, if I sat down, I knew I could never get up again, right? If I sat down to rest, I knew I would never manage to stand up and walk out, and they would have just found me dead up the mountain, right? And so that kind of thing is kind of my life, in the sense of I keep moving, because if I sit down, if I stop, I don't know that I'll ever be able to start again. And can't accept that. I can't like take that. That's, so I keep going, right? And sometimes I need like a couple of days or whatever, but I'm not gonna stop because I can't and I don't know how. And quite frankly, if I can see a world where I can't do any of these things I love doing. I can't help people. I can't interact with people like I am right now. And that terrifies me, right? It just absolutely scares the shit out of me because I want to keep doing all of these things, right? I want to, so people in Chicago, I want to meet you. People who watch this channel, I want to keep doing all of that. Like, I don't know. It just, I'm kind of getting a little too introspective here. I don't know, but, yeah, it is what it is. How old are you? I am 46. So, I mean, Mrs. Runkle and I, maybe I shouldn't say this. Mrs. Runkle and I met with an architect. And the reason why is that this house, it cannot be our forever house, right? This house that we're in eventually is not going to be a good house. It was built in the 50s. This house is like 70 years old. And, but I love the neighborhood. I want to build on this house again, or build on this lot again. So, but the reason why we met with an architect is that I was talking to an architect who does accessible living. Because I anticipate that one day I will not be able to walk. I anticipate that one day I will not be able to, I might be with a walker. I might be in a wheelchair. I don't know. So we're looking at, eventually building another house and doing it from an accessible living design where like we put in either a lift or an elevator or something like that, such that we'll build a house and I'll be able to live there until I don't live there anymore, right? Until I don't live anymore. But, I mean, it's kind of terrifying to sit there thinking about these things and be like, one day all of these things I want to do, I won't be able to do. One day I won't be able to, so scares the shit out of me. Like, honestly, it does. And, yeah, I have said before that I know that there will be a point in my life when I have my last pain-free day. And the worry I have is I think I might have already had it. Because I haven't had a pain-free day in over a year. Scares the shit out of me, right? I just, and I don't know if there's another pain-free day I don't know if there's another pain-free day to come. It might be this is just how that is for the rest of like time. And so yeah, it's things I got to think about, right? So yeah, I do what I can to manage it. I fight through, and used to be I could expect like 6 pain-free days. Then it was 4, then 3. I don't know. Maybe it's the last one. I don't know. ASG says, as someone with Suaheli and Haida ancestry, so thank you so much for talking about Indigenous issues. People forget about us. I can't say I'm always like the best Indigenous, ally, representative, whatever, but some of that stuff matters. All right, let's cover super chats because I am behind. I think in song lyrics, cheers to Kelsey. So, yeah, absolutely. Sorry, I'm just feeling a little introspective. So, Brentwood Chic, celebrating face. Love that. I had to figure that out for a second. It was a tiny little emoji. Jeff fell in emote. Thanks for spending time with us. It's been an incredibly sad week after losing 2 coworkers, and I'm happy to see you. Jeff, I'm sorry about that. Are you in aviation? Because we just had a thing here with aviation things. So, yeah. Meme Empress, the liquid in that glass is baby formula. Nope. So, yeah. Corgi Grandma, any more German stories? You made me laugh so much yesterday. Yes, but maybe not. Maybe not tonight. We're winding up. I got to get into a hot bath. Glamasu says, in celebration of Kelsey's acquittal. Plus, I want to know what's in that drink. Looks like condensed milk. I mean, it's tasty. Vomit fountain. I got to know what's involved in a Runkle cocktail drink. We'll make that happen. Meme Empress, I hope Kelsey gets Caden back soon too. Me too. She should be getting visitation at least. Justin's got Furby eyes, no blinking. Yeah, the doll eyes or shark eyes thing is kind of a weird feeling. Hi, Runkle. Thanks for the coverage. Do you think the judge was... Oh, I got hiccups. Put off by the Commonwealth using the gun as a demonstrative? He seemed wildly uncomfortable with the ballistician. If I was the judge, I would have said, you cannot do this. You cannot wave the gun around, right? So, not allowed. Shay says, didn't get the chance to send last night. I might have a cocktail that tastes like the spicy tamarind candies from Mexico. Your drink should be bitter and sour. Make a sweet drink recipe for the missus. I did see that last night, and I will figure that out. I'll have to do a Mrs. Runkle. Our CERN, I make old fashions using habanero bitters and mole. Where would I find habanero bitters? That's a question. Kat Randall, thank you for the gifted membership, and thank you for becoming a member as well. Observe Thyself, thank you for signing up. Kristen M96, I'm behind, but what about a drink with Red Bull called Sleeping on the Sidewalk for the Depp trial days? Didn't you drink a lot of Red Bull then? I did, because I had to. I was so exhausted. And I don't know if my back has ever quite recovered, but yeah. So Jen Doggos, L Fair, Jody Callahan, thank you for the 5 gifted memberships. Much appreciated. Vomit Fountain. I, for one, would love to see what Runkle considers a weird drink experiment. Will it involve the flamethrower? No. ASG, horrible cramps this week. Downtime for steno practice. Currently horizontal listening with a headache and happy for the pseudo company. Happy to have you here as well. Amanda Florentin, you were great on Defense Diaries today. I like the Matas. They're great people. And it was really nice to meet Judge Erskine today. Pamela Wissenbach, I'm down for weird drinks. It was a weird experiment. Emily Ahrens says, Kelsey got shot in the chest, yet she seemed to have better recollection of details, including the med flight. Noonan hedged. Also, she can't be a rookie and a super cop. They wanted it both ways. They did. Megan, not the stallion, but did Bradel impress you at all? I've been a criminal defense attorney for 15 years, and I thought his closing sucked. That's fair. I think that his closing was okay, given that it was I'm just going to say, it's a bench trial. All his closing needs to do is not fuck up. That's really what it comes down to. All his closing needs to do is not fuck up. And I think he didn't fuck up. So, was it the most impassioned I've seen? Nope. Did it go through the facts in the clearest way that I've seen? Nope. Did it get the job done? Yeah. Judge decided already before. Judge had made a not firm, but a Judge made a preliminary conclusion before he heard the closings, right? And so all he needed to do was not talk the judge out of it. And that's what he did, is he didn't talk the judge out of it. That's fair, Megan, not the Stallion. I get where you're coming from. It wasn't a super impressive closing, but it didn't fuck up. That's all it needed to do. Jody Callahan, thank you for the 5 gifted memberships. Joy W for the experimental drink. I've had elderflower gin before, but not with fizzy stuff. I will have to try there. And yeah. Harbinger of imminent death. Have you ever seen a judge order COs to seize a pew-pew from someone on the stand for being reckless with it? All right, I will tell you a story. I had a trial where the officer kept very intentionally pointing the gun at me, like specifically at me. And so, like, there were many guns in this trial, and every time he was asked to clear the gun, he'd point the gun directly towards me. And eventually I stood up and I said, Your Honor, I'm going to ask that you instruct the witness to stop pointing guns at me. And the judge said, oh, it's okay, they're cleared. And I said, they're not cleared, Your Honor. He's clearing them as he points them at me. And he says, well, I'm sure they were cleared before they were brought in the courtroom. I said, okay, I haven't cleared them. I'm not required to trust his clearance. And the judge says, well, Mr. Runkle, we're going to move on. I said, Your Honor, we are not going to move on. It is a criminal offense for him to point a firearm at a person, whether loaded or unloaded, and he keeps intentionally pointing it at me. So, Your Honor, if he's going to keep doing it, I'm going to arrest him. Because in Canada, you can arrest as their citizen's arrest. And the judge was like, oh, Mr. Runkle, you're not going to arrest him. I'm like, Your Honor, I will absolutely arrest him. And the judge says, officer, could you point the guns at the wall instead of Mr. Runkle? It's like, fuck yes. Thank you. Like, I was going to stand up. I was going to walk over there and I was going to go, you are under arrest for pointing a firearm. Because I was getting fucking pissed. Because he just kept pointing the gun right at my face. And he was looking at me every time he did it. He was trying to, like, big dog me about pointing a fucking gun at me. And I'm like, you do not get to point a gun at my face in court. Fuck you. So, yeah. Was that a sidebar? It wasn't a jury trial. It was a bench trial. So it was just, objection. Stop pointing the gun at my face. This was not the prosecutor. This was a witness. This was a police witness. And they were trying to introduce like a dozen guns in this trial. And so they'd hand him the gun and he'd clear it. And then they would ask him, is this a gun that you seized from the crime scene? He's like, yes. Okay, marked as exhibit, like whatever. But every time he was clearing it, he would aim it directly at me in order, and, as part of clearing it. And I'm like, no, fuck you. Yeah, I was so pissed. I was so mad. And, yeah. But is he better or worse than Russ Trial Guy? Russ Trial Guy was a farce and pointed the gun at the judge. So better. Nancy Drewby, have a cocktail for me, Runkle. Fell today and broke my wrist pretty bad on pain meds and surgery Tuesday. I am really sorry, Nancy. I hope that goes smoothly. And, yeah. I was so worried this was going to be a guilty. This is Massachusetts, after all. I have a bit more confidence in the jurist now. Yeah, absolutely. Was I able to use it to advantage in my case? Not really, other than just telling the cop to stop pointing the gun at me. I know tired, but please pup swoop before good night. We can do a pup swoop right now. Most of my trials have been bench trials. They are very common. And I like doing gun stuff. Most gun stuff you don't want to put in front of a jury because you don't know what the jury thinks about guns. The Lady Draconis, thank you so much for 10 gifted memberships. And Swanee U3P, thank you so much as well for 10 gifted memberships. Mirage of Reality in Minnesota. With my therapist during verdict, coincidence and timing, made her wait so I could listen, told her we'd have lots to deal with if guilty. Fair. So yeah. That is actually really funny. So so Braden Culver, in hindsight, I think the opening saying immediately saying it couldn't have happened the way she and defense said it did kind of proved some burden shifting. Yeah, I mean, they still have to prove their case beyond a reasonable doubt. Becca became a YouTube member, much appreciated. What is it? Somebody's like, Thirsty Pupper is my favorite swoop. Let's... Yeah, that is awesome. Are you covering the OnlyFans trial in Florida next month? I don't know. I haven't decided yet. Becca, thank you for joining. Welcome aboard. Chris K, thanks, Runkle. Thank you. Harbinger of imminent death is the object an exhibit. Does the judge get to play with it in chambers? Yes, if the judge wanted. I don't think the judge handled the gun in chambers. Would they say to a jury, here you go, have fun, be safe? Normally, when they allow a jury to look at a gun, they're going to make sure there's no ammo in the room, and they'll probably keep an eye on them because, you know, you don't want the... I mean, the worst case scenario is a juror pulls out a round out of their pocket and, you know, puts a hole in something. So, yeah. Did you all see the owner of OnlyFans died today at 43? That I thought was something. Try near infrared light, life-changing 30 years in pain. I haven't tried it. I might have to try it. So I'm still wondering if Kelsey's Glock could have clicked because it was held out of battery and not on an empty chamber. I don't actually know. I'm going to have to see. I don't have a Glock here. So I'm going to have to get a Glock to play with it to see. So I can't answer that question for you right now, Law Girls. But it's not a bad question. It's a good question. Braden Culver says, I can think of a few other ways to kind of load the gun, but they're all really dumb. You probably shouldn't muzzle load a pistol, but you could with a mod. Yeah, that's fair. Kelly Durazio Healy, thank you for your insight on this case and others. I enjoy listening. Enjoy your drink. Well deserved. Thank you. Always get a lawyer. How could they find 17 bullets in the gun if the chamber was empty at first? With an empty chamber, wouldn't the maximum capacity be 16? The maximum capacity of the magazine is 17. The chamber can hold one more. So in theory, the maximum capacity of the total thing is 18, which is the 17 plus one in the chamber. The Jet JJ, thanks for the extra entertaining commentary tonight. Thank you. Have a Caesar to celebrate your coverage of this case. You deserve it. Thank you. Kristen M96, because you get to talk to him, send Rob our love. Thanks. I will tell him everybody loves him. Random unprinted commenter, motion for pigeon business challenge coin. Fair. Jamie 143 Kevin, Caesar. Yeah. Amanda Florentin, cheers to today's verdict. Thank you. And cheers. Kimchi the forensic homeopath. Why can't you dry fire 22? Also, if you ever get into the D&D minigame, I want a mini Runkle to menace my players with. So the reason why you can't dry fire or shouldn't dry fire a 22 is because the 22 is how do I put this? If you dry fire a 22, you can end up damaging either the firing pin or the chamber with regards to the firing pin. So what is dry fire? Dry firing is you fire the gun empty, right? So the gun has no ammunition in it, but you fire it. Now, dry firing is used quite commonly for practice. And the reason why dry fire can be really helpful for practice is let's say I want to practice my draw fire, right? So I might draw the firearm, present it out, and fire. And I am holding the gun on target that entire time. So, like with my transparent plastic toy, you've got it, and the thing about dry firing is that it means you can hold it stable and you can see if you are jerking the trigger, if you're doing whatever. It helps you practice proper trigger pull, right? And proper draw, proper all of the things. So, yeah. Somebody was asking, would you ever consider doing the spin the wheel thing Defense Diaries does on their channel? I've done wheels before. Yeah. Somebody else asked, what does it mean to fire out of battery or for a held out of battery? So the slide is supposed to be all the way forward, right? And when the slide is all the way forward, the gun is basically a closed up system. It's locked up, and so the breech face is right up against things. It's holding it tight. And so if you have the gun out of battery, the slide is back and it's open. It's not properly closed up. Now, in that state, a gun shouldn't fire. But sometimes a gun can fire in an out of battery state. And usually this is a very bad thing. Because usually if a gun fires out of battery, it might mean that the gun is about to explode or something else like that. So a gun should not fire out of battery, but sometimes they fuck up. So yeah, it's a whole thing. D2 Finch, thank you for the super sticker. How's the Runklebot doing? Runklebot. Runklebot is doing just fine. So yeah. M4085, peel the layer off the pigeon pin. I'll take it. Probably a little late. Sue, thank you so much. How can we order pigeon pins? I got to put them up on the website. I got to figure all that out. It's a pain in the butt, but I'll do it. Music to my soul. I was thrown off by how the judge reacted to Bradle's objections. It made me worried at the time that he was leaning towards guilty after closings. I kind of had the same feeling. I was worried. Walking, talking, Stephen Hawking. Perhaps the Commonwealth could have met their burden if the officers had been wearing some body cams. Want some ice for that burn, masshole? Yeah. Music to my soul. We got Mrs. Runkle chiming into the stream from off camera before we got GTA 6. Nice. Fender, no getting pew-pew to meet people. No, bad, Ian. Fair. Michigan Farm Boy, watch Leto's Law, never buy an RV. He recommends renting if you must RV. Good series to watch. You're not wrong. What is it? Lone Star Living 24, YouTube shorts for years, RVing with Runkle. Call Kirk, he will navigate and film. Fair. I think that was probably Kurt. Lazy LCH, was it Bloodworth's Elephant Slide and Richens circumstantial evidence? Yeah, that was odd. Horse Welfare, have you seen the movie Four Rooms? It's good. I have not. I'm not aware of that movie. Kimchi the Forensic Homeopath. Scorn is absolutely unwarranted. Thanks. I'll scorn them even harder. Love it. Horse Welfare 5744, Runkle Planes, Trains, and Automobiles, a documentary. Nick Starro says, tell that to Sandra Birchmore, Judge. Ooh, that is a solid burn, Nick. That is amazing. Michigan Farm Boy, it looks like Mark wasn't entertained by the judge's preamble, especially the part about police when they showed him. Yeah, there's that. Walking Talking Stephen Hawking says, as soon as he started writing LEO, I knew he was going not guilty. Also, Ian, don't sell yourself short. Bettero is obviously a big fan of yours as well. I never know how people feel about me. And that's part of my imposter syndrome, is that I always think everybody around me is like, yeah, these people suck. So, yeah. Little Lilacs and Chocolate. My grandparents once drove from Vermont to Alaska and back in their RV. Then they did it again on a motorcycle. It can be done. Yep. Fine line between out of battery safety and an auto sear. Yeah. Yeah. A Glock auto sear is a whole thing there. Yeah. Don't put an auto sear into your Glock, right? Comment on lawyer Gurpreet Singh Gill disbarment. Oh, I think this is one that is on my list of things I have to do a video on. Gurpreet Singh Gill disbarment. So he is a situation where, so he was disbarred, and he was disbarred for, amongst other things, the allegation is that he showed naked video / photos of a client to a prospective employee. An employee was like, hey, I want to work, or a person was like, I want to work for you. He's like, let me show you some client porn. Let me show you some client porn. And then that got reported to the Law Society because what the fuck? And his argument was, well, I need to know that you can deal with tough shit. And it's like, yeah, you can't. Then he then forged documents to say that the client whose nudes he showed was okay with it. The client was not okay with it. But instead of like getting the client to confirm they were okay with it, he instead just like faked the documents to say the client was okay with it when they weren't. And so the Law Society was like, having heard your arguments about why you should not be disbarred, our ruling is kill it with fire. And yeah, so he got super disbarred. Just read that. Johnny, he may have shot to save, and ironically did, but sad the lies and worse the case was heaped on top. So happy she got justice. Love the great coverage. Thank you. I mean, you shouldn't try to shoot somebody to save their life, but I get where you're coming from there, and it might have actually. Graceful answers. Any advice for mock trial kids doing prosecution side kid? Make sure you're prepared. And the other thing is that even though you're doing prosecution side, think about the defense. Think about what they're going to be arguing, and then prepare for that. So, yeah. I need a pigeon pin. Will be so perfect as a gift for a friend. How will you list them for sale? I have a Shopify site. I'll probably put them up there. So, yeah. I see people talking about garlic stuffed olives and lemon stuffed olives. And now I'm thinking I want to go to the Italian Center tomorrow to go pick up some more olives. So I need some. I prefer the way Canoni ruled in McGee. I've read the papers and considered the evidence. Ms. McGee, please stand. I find you not guilty. Peace. The judge doesn't have to give reasons. The reason why the judge gave reasons is because this is such a contentious thing. And if the judge just stood up and said not guilty, the internet would be full of people saying Noonan's a lying sack of shit. Now, I still believe, personally, is my opinion, that Noonan is a lying sack of shit. But I can't say that the ruling was that Noonan is a lying sack of shit. I can only say that notwithstanding the ruling, my view of the matter is that Noonan is a lying sack of shit. And that, you know, I can have that opinion about Noonan being a lying sack of shit. And that is how that goes. Rob Price, I will in just a second. So, yeah. I forced my Glock out of battery in as small as increment as possible and it would not fire. Trigger will not pull back even a little bit. So fair enough. Not all firearms are that way, but most are, because that is how that goes. Michigan Farm Boy, if you were one of these less knowledgeable lawyers and your client had some, how much can you trust a client's info and feel like you're doing a good job? Or does that just give info to find the expert? I always want to check my client's info because I don't necessarily believe my client. And if I can back up my client's info, then anything I find that backs it up is also corroborating evidence, right? John and Nini, so happy she can now use the courts. Boom, justice. Love it. Trixie Fire, what do you think a jury would have decided? I don't know. And it really depends on the makeup of the jury. Cat's Pajamas, why do they seal the records? And is there any reason a person would want the records unsealed? You might want the records unsealed if you really wanted all of this stuff out, but they seal the records because that's just the law, right? The law says seal the records, otherwise, unless the person asks not to. Shanta, the lady in back holding the purple sign is Melanie Little Sub. I assume you mean subscriber, because otherwise that's a lot of information that I assume you're not saying what it. Okay. Kelsey and her lawyer know Melanie did gavel to gavel. She has a link and QR code to her GoFundMe to help with her attorney's fees. I'm just like, I'm trying to parse this sentence. That was from Justice Served. He meant how long he took to say not guilty when delivering the verdict. Okay, fair. I was unfair to Justice Served. I misread it. Honk Banana No, thank you for the 10 gifted memberships. Much appreciated. Sandy, we heart you, Ian. Thanks for the great coverage. Thank you. Chelsea Rama, thank you for the great coverage on this case, Runkle. Appreciate all your knowledge as always. Thank you. Michigan Farm Boy, I was watching Lawyer live at the verdict, and he flip-flopped based on judge's comments a couple of times. I mean, the judge was like, hey, I'm going to convict. Hey, I'm going to acquit. Yeah. Piney Woods Law and Crime became a YouTube member. Welcome aboard. Sorry, I'm not quite clear. What's your opinion of Noonan? Not good. Not good. I think that Noonan has things. What is it? No kink shaming, good life rule. I'm not kink shaming. I'm just I was just like, those are words. I don't know what those words mean. So walking talking Stephen Hawking. Bradle said they alerted the FBI about a break and enter. FBI saw a Massachusetts area code and answered, what now? Love it. Jaded for Justice, can you point me to your Sunchild video? I'll have to try to track it down. I'd have to actually search. Michigan Farm Boy, the Sony versus Cox Communications SCOTUS ruling should be good for product liability for arms and other products. Generally, we can't sue for unintended use of otherwise legal products. I have not read that decision yet. I saw a video on Leonard French's channel, but I haven't had time to watch it yet. So that'll be something I got to do, is catch up on that. My sunshine, I'm behind, but this is an appreciation of your humanity and your offer to Kelsey to help her get whatever life and wishes have to offer. Her life turned to shit, and it's time that finally turned around. I think she could actually do pretty well with like a YouTube channel, right? She could talk about policing. She could talk about her experiences. She could, yeah. Need to seatbelt the new pew-pews in the back seat while traveling. I didn't think I would need to. Engineer Your Life. Hi, Ian, sent you a DM. I'd really appreciate your thoughts. Might be of interest. I need to get back to you, Engineer for Life. I did see that. My life has been chaos, so I haven't been able to reply to it in full detail. But yeah, sour, bitter, and a big bit of sweet sounds about right with your background. Really appreciate all you give in the various areas of life and your interest. Thank you so much, Michigan Farm Boy. Book Dragon KSC, you're touching on my dream. I want to design pro bono to help people stay in their homes and make them accessible. That is amazing. That is awesome. VW Stillwell, I understand your fear with your back and what life looks like at some point. I've lived with it since I was 16 and found out this year I have scoliosis and ankylosing spondylitis. Sending energy. Fist bump is, I guess, what I have to say on that. Let's hope we both have the best possible outcomes. Piney Woods Law and Crime, thank you so much for the 10 gifted memberships. Light Queens, thank you so much. Graceful Answers, got a mock trial question for you. Discord mess you. I will see it in a moment. Casey EKG, thanks for reminding me I don't start enough sentence with "Hey fucko." I regret that sentence. It, yeah, my bad. Do you know why Kelsey's family law attorney started appearing in court with the defense part of the way through Kelsey's trial? Because, I mean, the verdict on this is going to be huge for her family law thing. Because if she was convicted, her family law file would be massively screwed, right? So, Ruth Christie, I experienced a suicide. My neighbor shot himself through his head. I found him. It was horrible. I hate guns from the UK. Fair, but, I mean, I have positive experiences with firearms. Different things, right? Please, I'm begging you, tell us the story of the lawyer with no pants. I will cover it in more detail on Monday, but the allegation is that that a lawyer appeared in court on Zoom and that he stood up and it turned out he was Winnie the Poohing it. Like shirt, suit, jacket, tie, no pants. And yeah. So that is a whole hell of a thing, right? Because you're not allowed to Winnie the Pooh it. I just want to show you. This is my knee. You will notice that my knee is entirely in panted pants. So, I see people saying he did have underwear, though. I don't know. I don't know if he had underwear. He might not have. He might have been like swinging worm. So, like, dunno where that was. I have not gone through the full thing yet. Light Queens was diagnosed with scoliosis at 11 years, told many times I'd be wheelchaired by 45. I'm 52 and still going. Awesome. I love that. That is amazing. So yeah. Well, that one guy on CNN who was on Zoom was doing way worse and he got his job back. Oh, you're talking about Tubin. Tubin, who was Tubin. That was we also had a Canadian member of Parliament who appeared naked on Parliament meetings twice, and he was not kicked out of the Liberal caucus. So that was a thing. Yeah. Anyway, I think that this stream has kind of verged from off the highway into the ditch. And So let's wrap it up here. I will definitely see you guys on Monday, and we will we'll talk soon. So good night, all, and thank you so much for joining me. It's been a wild ride, and yeah, have a great evening.